Thank you. I open the public hearing on Children and Family Law Committee for Tuesday, February 4th, 2025, and a couple of business items first. Prime sponsor of House Bill 553, Representative Gregg, requests a subcommittee to do some work on it in the hopes we can exec it fairly soon. And the chair appoints Representative Gregg to chair this. That means when you schedule, you've got to go to the committee assistant, Special K, and let her know. And that means it's by Wednesday noon. I also appoint Gabby Grossman, learning the name. It's been 3 years. Deb DeSimone, Kim Rice, and Jody Nelson to this subcommittee. We also welcome two replacements, and if the replacements would introduce themselves.
I'm Representative Buzz Scher. I'm normally on House Criminal Justice. I'm from Rockingham 26, Portsmouth Ward 3.
So if you hear a slight buzz over in this end of the room, he's buzzed, but he's not slight. And also,
I apologize for the chair.
And I'm Janet Lucas. I'm from Grafton, District 7, which is Campton, and I'm usually on Health and Human Services, Elderly Affairs.
My old committee, yes.
Right.
All right. And I got some more announcements that I will be making later. I open the hearing now on House Bill 486 relative to grandparents' visitation rights, and the chair recognizes you. Representative Nelson, with the clerk's duties now being assumed by our deputy clerk. 486 we have. And just a reminder, continuing education, if somebody speaks from the witness table on a bill, that means when they return to their seat, if they're on this committee, they are not allowed to ask questions of others who testify. But there is a workaround, which I explained the other day, and that is when I was on Health and Human Services, I was sitting next to Dr. Jerry Knurk. And he introduced the bill, and he was just sitting there dying to ask questions. So he handed me a note saying, ask this question. And all would have gone smoothly, but I did say, Dr. Knurk. And of course, a sentence in, his handwriting degenerated, and I looked to him and said, Jerry, what's that word? And that kind of gave it all away. But generally speaking, that's the rule here. So, please introduce your bill to us.
Thank you, Mr. Chairman, and thank you to members of the committee. I'm here to testify on House Bill 486, and I am the prime sponsor. A constituent brought her issue with real trouble she was having being granted grandparents' visitation to me, and asked me to look at RSA 461-A:13. As I started to research and speak with other grandparents and people from organizations who help grandparents, I realized that there were some changes to current law that really needed to be made. I tread very lightly because of my respect for parents' rights and didn't want to encroach on those rights when I was trying to think of language that would help grandparents. I was relieved and very thankful that two very active and influential parents' rights supporters signed in support of the bill, so I believe I have successfully accomplished that. What did I do? I added separate living arrangements to circumstances to supplement the circumstance of divorce. As we know, divorces can take years, and it's not in the best interest of the child to wait years to continue a positive relationship with their grandparents. This could interfere with the frequency of contact consideration also, depending on the interpretation of divorce in this instance. Is it fair to determine that grandparents should be disqualified because they haven't seen their grandchildren during the course of long divorce proceedings? How do judges determine what the definition of divorce is in this case. Is it after the final decree? Is it during the course of the divorce? It seems like there really isn't one answer, and it's open to a lot of interpretation. We've also seen a lot of grandparents in New Hampshire raising grandchildren. As we know, we see them a lot here in our committee. And I've seen estimates up to 12,000 grandparents currently who are raising grandchildren in their homes. And as we know, unfortunately, a large contributing factor to this huge population of grandparents raising grandkids is due to parental drug abuse. Many grandparents have temporary guardianship for several months, 6 or more at a time. And while the goal is often reunification, and we hope reunification with the parent or parents is permanent and successful, the reality is that recovery can be a bumpy road. Grandparents can be going back and forth from parents to grandparents as their parents are battling their addictions. Maintaining a positive relationship with grandparents is crucial to the well-being of the child in situations like this. This is why I've added the language in lines 15, 16, and 17. This language is in current legislation in other states, and it seems to be working. I found an article in a help guide for grandparents entitled Help for Grandparents and Kinship Caregivers Impacted by Opioids or Other Substance Use Disorders about understanding attachment and bonding. Long title, sorry. I just wanted to read you a portion of that article. It does a great job explaining why this is important and to justify adding the lines I'm talking about. Young children need to develop at least one relationship with one primary caregiver for healthy social and emotional development to occur. Children become attached to the adults who are sensitive and responsive to them and remain constant early in their life. This person is their secure base. Children who experienced a parent's substance use disorder may have felt abandonment due to their parent's absence or lack of attentiveness to their needs. And children who have been removed from their birth parent and go to live with their grandparent or kin caregiver develop an attachment to them. The total loss of that attachment person can cause anxiety and grief in the child. That's why it's critically important that the unification planning for the child must include mechanisms to continue at least one relationship with the bond with the grandparents or kinship giver, while at the same time strengthening the parental bond. This shouldn't be a them versus us type of situation. That's about it, and I hope I've communicated the need for these changes enough for you to support the bill, and I would be happy to take questions.
Any questions? Representative Gregg.
Thank you, Mr. Chairman, and thank you for presenting this bill and for taking my question. How did you come on the time frame of the 6 months?
Thank you for the question. I researched all of the laws, all of the grandparent visitation laws, and that's in statute in other states, including Arkansas, exactly how it's written. And I had not found there to be any problem with that in those states, and that's where I got that exact language.
Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question. So I'm curious about the stipulation that the child has to have lived with the grandparent for the grandparent to have visitation rights. Does the language change make that requirement, or can it still be a situation? Like, I'm thinking about a friend of mine who goes to her daughter's house every day, gets the children ready for school, takes them to school, and then watches them after school. Should something happen, she would probably want to continue to have a relationship with those kids. Would that still be something that a judge could order? Or because she doesn't actually physically live with them, does the language change that?
Thank you for your question. It doesn't change at all. It's just an addition to what we have currently in statute. Thank you.
Seeing no other hands up, thank you so much.
Thank you,
Come on
Mr.
back.
Chairman.
And the chair recognizes Mr. Frank Kurland. He says he's got testimony that came to us online. That we have 2 seats. Can you share a microphone in a nice way?
Thank you.
You've worked that one out, yeah. My wife and I say the first 37 years are the hardest, but I'll allow it. It's okay. And the hardest part of testifying is making sure your microphone is on. And you know it is when there's a red light looking at you. You got to push the button, though. Bingo.
Good morning, Chair and members. I'm testifying today in support of the grandparents' visitation law. Grandparents have always been and continue to be an integral part of the family for millennia of generations. They are the keepers of wisdom, care, and tradition that binds the legacy of the collective family. Grandparents are the peacekeepers, the confidants, and the protectors, a safe haven in the storm. Parents who exploit this trust with self-absorbing agendas to the point of attacking the very people who supported and cared for them in their childhood are ultimately damaging their own children without morality by denying any contact with grandparents. Those parents who gaslight their own offspring to again attack the only safe haven have lost their way. Grandparents need to continue to be part of the grandkids' lives and vice versa, without question. I ask this committee of lawmakers to take the high road and pass this legislation unencumbered. This is in the best interest of the kids, first, last, and always. Any questions?
Any questions? I just want to look at their picture for another 30 seconds. That's so good. I'm going to guess you're a grandfather.
I'm a proxy
To
grandfather.
me.
Got it.
I'm the grandmother. He was their adopted papa.
Okay. Any questions? Well, seeing none, thank you so much. Appreciate you coming. We'll allow you to take the photos back, okay? Yeah. Chair recognizes Deborah Konar, is it? Do I have it right? Oh, okay, counts as one. Thank you. Chair recognizes Stacy, DBA Mimi Tarosian. No, it's all right.
Good morning, Mr. Chair and committee members. My name is Stacy Tarosian. I'm here as a very, very concerned grandmother. But I do support this bill with some recommended changes. My granddaughters have been alienated and isolated from me, not just me, but my entire family that has loved and supported them. For the last 2 years, we have not seen them or had any contact with them. After 18 months of litigation, my case was dismissed due to the language in Section 1 of this current RSA. This language weaponizes bad parents against good, loving grandparents like myself who seek visitations with good cause and concern for the safety and the well-being of their grandchildren. Particularly in situations where there is a genuine risk of abuse and neglect in the house. Most grandparents seek visitations as a way of providing a lifeline to the grandchildren in case of adverse circumstances, and the children needing to be reunited with their grandparents. Well, Judge Cooper, he granted me visitations.
No names,
Oh, I'm
please.
sorry. At 2 separate hearings in which my daughter would not comply. In August 2024, we were scheduled for a contempt hearing for non-compliance of his visitation orders. And as I walked into the courtroom, I was ambushed with a new judge who I'd never seen before and who I believe was not familiar with our case history. And my daughter's attorney presented me with a motion to dismiss that I had never seen till that moment. I was not given 10 days notice or any time to appeal. My contempt hearing now became into a hearing to dismiss my case. After 18 months of litigation, the other judge was no longer hearing our case. The other judge knew the extenuating circumstances of this case, including the history of child endangerment, neglect, drug and alcohol abuse, assault and battery, domestic violence, and mental health issues, along with 2 incarcerations in which I was the primary caretaker of my grandchildren, and many DCYF assessments. In 2019, When my daughter separated from her husband, my daughter and my granddaughters came to live with me for a year and a half. And during that time, my daughter became incarcerated for child endangerment, and I became the primary caretaker of my two youngest granddaughters, who were only 1 and 2 years old. At this time, my daughter lost custody of her eldest daughter to her father, but she would come and spend almost every weekend with me and her sisters. My daughter to this day still does not have custody to her eldest daughter, who's 12 years old now. After my daughter was released from prison, she moved into an apartment upstairs from me with my two youngest granddaughters. So I would be close by to help with the girls and be a constant support for her. Well, 2 years ago, my daughter suffered a second overdose on heroin laced with fentanyl, while my 3 grandchildren were present in the home sleeping. And as a result, DCYF placed the girls in my custody. After providing 9 months of care, during which the girls showed remarkable improvements in their health, they were happy, they were thriving, and I supported the reunification of my daughter with her children again. Immediately following this reunification, my daughter, who was still separated from her husband, now restricts all contact between myself and my granddaughters. This judge, based on his interpretation of Section 1 of the RSA, stated, because I was restricted prior to the absence of the nuclear family, as in Section 1 of this RSA, that I had no standing, no grounds for grandparent visitations. And he had no power to grant or enforce any visitations or rights to me as a grandmother. And he dismissed my case. And again, that was his interpretation. After 18 months of litigation, even though I had 2 granted visitations at 2 separate hearings, with the last being a final order with a visitation schedule, my daughter refused to comply and was held in contempt, but there was never any consequences. There was no penalties, no repercussions for non-compliant and being in contempt. Because my daughter was separated, not divorced at the time that she restricted me, upon reunification, I have no recourse to ever see my grandchildren again, who I loved and I nurtured their entire young lives. She is now divorced, but I still have no rights to petition the court for visitations. How is that fair to the children who love their grandmother? This not only hurts me, but it hurts my girls emotionally, being ripped away from me, their loving Mimi. They spent so many years with me, and I miss my granddaughters dearly. I'm sorry. The isolation and alienation, it's not fair to them, it's not fair to me, it's not fair to my family. For the last 12 years, I was called Mimi, and I no longer hear those voices anymore. Nobody calls me Mimi anymore. And I'm grieving the loss of living grandchildren that are just in the next city over from me. In August 2024, 7 months after reunification with their mother, I became aware that my youngest 5-year-old granddaughter was severely burned using the microwave, preparing her own meal while my daughter was in bed. This caused me great concern and worry for my granddaughter's safety and well-being. I strongly support this bill with recommended changes so that all grandparents have the right to visitations and relationships with their grandchildren. And I urge this committee to do the right thing and pass this bill. Other grandparents are suffering like myself. And we just want to be a lifeline to our grandchildren. And unfortunately, when your child is involved with drugs and alcohol, they don't want the children to be involved with the grandparents because they're in fear. They're in fear the children will unknowingly say something to the grandparent that could get the parent into some trouble. So it's fear to isolate everybody so nobody has access to what's going on in that home. And in one of the pictures I showed you that I passed out, I went to go, that was a visitation. I was supposed to go get my granddaughters. They didn't come out, but all the windows were boarded up with cardboard boxes and sheets. So my poor grandchildren can't even see outside in the daylight. They can't see outside, and I couldn't see in. In 2 years, she's had time to brainwash them all against me. The loving grandmother, I sacrificed so many years and so much of my time and energy on these beautiful little girls to be ripped away from me.
Will you take questions from
Yes,
us?
absolutely.
You suggest some changes to the bill. We will vote on this bill at some point, and we could possibly make changes. Do you have the suggested changes written out for us?
I don't at this time.
Okay.
But it was that current line that I was restricted prior to the absence of the nuclear family, because she restricted me while she was separated
Okay.
for any reason. And he said the court has no power to grant me visitations.
What you just said would be very helpful if you wrote that out for us.
Okay.
Absent that, we grant you that changes could be made, but we will not know how to make those changes. We will vote the bill as we have it.
Okay.
But if you have specifics, please get them to us as soon as you can. And then when we go to discuss it in committee, it is possible that an amendment could be crafted.
Thank you.
Thank you. Representative Raymond.
Thank you, Mr. Chairman. That was my question about the specific language changes. So
Representative Greg.
Thank you, Mr. Chairman. Thank you for being here, and thank you for taking my question and sharing your very painful story. I just wondered, because I want to wrap my head around the legal side of this, did you appeal that decision? Because with the first judge coming in and the second, was there any kind of appellate situation with that?
The first judge granted, I had 2 hearings, temporary and final. At both hearings, he granted me visitations. So I wasn't expecting it to be a contempt hearing. I wasn't expecting it to be a hearing to dismiss my case. It was supposed to be for contempt. And the case got dismissed. So no, I did not appeal it because
You didn't
because
appeal
of-
the second decision.
I didn't, because the way he said it in the law interprets it. He interpreted it that I have no rights. He had no power to grant me visitation because the way the law was written, I was restricted prior to the absence of the nuclear family. And even though he had moved on in another relationship and wasn't living in the house, he considered them a nuclear family.
Sure.
Were you represented by counsel at this hearing?
I was pro se.
Okay, but the opposite was of counsel?
Yes.
With counsel?
Yes.
Yes, okay, thank you. Representative Petrino.
Thank you, Mr. Chairman, and thank you so much.
Of
I
course.
just want to say that I am a papa to 3 grandchildren who I love dearly.
Yes.
And I cannot imagine being alienated from them. So I hear your testimony and I feel your pain, and I just want to thank you very much for being here.
You're welcome. You're welcome. Any other questions? And I had one other thing to say. We have over 170 supporters for this bill online and a lot of testimonies. I lobbied this bill because it's so important to me and dear to my heart, and it means so much to me to get this bill passed for not just me, but all the grandparents that are suffering like me and the grandchildren that are suffering, wondering where their loving grandmother or grandfather went. There is one testimony I would like you to read, and his name is Hubert Novell. His testimony relates to my exact story. He has gone through the exact same thing as I have. If you could read that one specific testimony, it might bring a little more insight into the language in this law that needs to be amended.
Thank you.
Thank you.
Thank you for coming.
Thank you.
And we will look forward to that document from you so we can consider amending it. I have a card for a Deborah Konar. Yep. Do I have it right?
No.
Do I have Deborah right?
No one ever does.
All right, but Deborah's correct.
Deborah is correct.
And your last name is?
It is Smar.
It is what?
Smar. Just pretend it's an S. C-M-A-R.
Got it. Thank you.
Thank you. Thank you for being here today and considering the amendment to this bill. My husband and I have 3 granddaughters, ages 11, 8, and 5. Our son and daughter-in-law and their growing family lived in our home with us for almost 3.5 years while they saved up and eventually built their house in Chichester. We are in constant contact with them, seeing them weekly and FaceTiming or messaging several times during the week. We always attend and support their extracurricular activities, have them over for sleepovers, often when their mother requests it to give her a break. We have rented houses on the Cape and Lake Winnipesaukee so our families can be together for vacations. Last August, after a long time coming, everything fell apart in their marriage. Our son was arrested. He has PTSD and substance problems, and a restraining order was issued against him. He has not been able to see his children since that time, but he would like us to be able to see them. We have continued to support our daughter-in-law and grandchildren emotionally, spending any time we can with them. In early November, we had all three girls over for a sleepover and everything was great. We were supposed to have them for our family Thanksgiving. That morning, our daughter-in-law texted and informed us that the girls were not comfortable with us and that she would not force them to see us. She ignored our request to have them for Christmas, which we previously were told would be fine. We have gone to our granddaughter's basketball games, and the girls will now not look at us or speak to us. Our granddaughters are being alienated from us and from our entire family. We have a very close-knit, loving family. We have never said a word to them against their mother and have only have their best interest at heart. We are trying to obtain visitation with them to repair the damage that has been done to our relationship. However, as the law is written now, we have little hope of that happening until their divorce is finalized, which could take a couple of years as it's very contentious. Outside of their parents, my husband and I have been the most consistent and supportive presence in our grandchildren's lives. We're the only ones who were ever allowed to babysit them or spend time with them. Her family was not even involved in that. We ask that you enact House Bill 486 to amend the criteria for grandparent visitation so that we can work at repairing that relationship. Thank you.
Thank you. And any questions for the witness? Seeing none, thank you so much.
Thank you.
I have no more pink cards on this, so I will conclude our hearing on House Bill 486, and we will put this one aside for a week or two, awaiting any further information before we go to vote on it. With that, I open the hearing on House Bill 320, an act relative to enforcement of marital property settlements, and Representative Markell from our committee is the prime sponsor. And at some point, you owe me a pink card.
Okay, I'm sorry, Mr. Chairman.
Your credit is good.
Okay, thank you. I'll get that in. And thank you for allowing me to speak on behalf, I'm sorry. Thank you for allowing me to speak on behalf of this bill. What 320 does is basically a couple of things. First, it plugs a hole in the current law. Two things I'm passing around. One is a copy of RSA 45816A, which is the statutory factors that courts consider when it makes property settlements. And what is missing is basically House Bill 320, and I'll explain why. There is no statutory requirement that any court enforce any of its orders that it makes once a decree has become final. Now, there's a difference.
Would you say that again? Because that is, wow, please.
Yeah, it is wow, and it's very unfortunate. To my knowledge, there is no statutory requirement that a court enforce a final decree when it becomes final. I haven't seen it, and the basis for this bill was a profoundly disturbing experience that I have had in a court in this state, where a court simply refused to enforce its decree, resulting in basically a significant deprivation of property. And unfortunately, decorum does not allow me to go into the specifics of the case publicly. I can tell you that the decision to enforce the decree was in part based on activity which in black and white terms rose to the level of perjury and was provable. I can also tell you it involved intentional conversion of assets, and the court, when presented with this evidence, simply declined to enforce its decree. Now, there's a difference between enforcement and contempt, and it's important that you know the difference between the two. Contempt is basically in New Hampshire, it's basically a willful or intentional violation of a court order. Okay, enforcement doesn't necessarily involve contempt. Contempt historically is discretionary upon a court. So a court can find you in contempt or not find you in contempt, depending on the circumstances. And it's largely discretionary, and that's historical since contempts have been in existence. When you look at 320, the elements that a court can consider in whether or not to enforce a decree are basically well settled. So I'm respectfully direct the committee's attention to paragraph 7, line 7, where, in other words, once a decree becomes final, that means no more appeals are allowed, or an appeal has taken place, or post-trial or post-decision motions have been resolved. There is basically nothing else to go on in terms of further activity. And that's basically finality of judgment. So when you look at what would be invalid, would be whether a decree was either entered into, either by agreement of the parties or after a final hearing by a court, would be fraud, deceit, duress, impossibility, misrepresentation, mutual mistake, undue influence, or subsequent illegality. And that would be shown by a preponderance of the evidence. Now, fraud, duress, deceit, misrepresentation, mutual mistake, and undue influence are well settled reasons to set aside a property decree in the state of New Hampshire. You can go back, case law, all the way back, and you'll see that. Basically, if you want to look it up, one key case on that is DiPalatino from 1995, which recites in its case, historic precedent for setting aside a decree based on that. I chose to add some contract information because that can become a contract. So when you look at the word impossibility, in other words, if somehow it was entered into and subsequent enforcement became impossible, or subsequent illegality, those might be reasons to not enforce a decree to its terms. An example of that, for example, might be, let's say hypothetically, one of the agreed upon things was to transfer 10 cases of an imported Russian vodka to be delivered 2 years down the road, and the thing becomes final. Well, all of a sudden, the United States decides to ban the importation of Russian vodka, and all of a sudden, compliance is impossible, or also illegal if it becomes a criminal activity to import Russian vodka. So those might be two defenses. The rest of it is, when you look at it, is basically contract law, which is a big part of what goes on in agreements and decrees, which is the court shall fashion remedies that place the parties in the position as if the decree had been fully performed according to its terms. Now, then this is important. And the reason why is because if for some reason there needs to be an adjustment, courts can fashion remedies that will put the parties basically in the same position. And it can be done. Now, the worst part of this is that you really do not have a viable appeal going up to the New Hampshire Supreme Court if a court below simply declines to enforce an order. And that is frightening. The other aspect of why this thing is written the way it is because I think, as we have seen on this committee, people need to learn how to plead their cases. Approximately 80% of the people who go into court, at least in the family division, one side of that case is probably a self-represented individual. So in other words, with this clear and unambiguous language, people learn how to plead their cases effectively. So they know, okay, well, what's happened in this case? Why am I here to enforce? Why am I here seeking a contempt? And what would the possible defenses that a court could accept would be? So you can argue your case effectively and plead it effectively. And that teaches, and that basically improves the administration of law. The second aspect of it is that courts need to be on notice that their ability to be able to enforce a decree, okay, is there. So a court can simply look at this and realize that it has to fashion remedies. And that basically put the parties in the position that they were in, if as if the decree had been fully performed. And the nice part about this language is that it allows parties, whether this is a decree by agreement or whether it is the result of a contested matter, that they can argue the case effectively. And so, without this statute, I am afraid that since this has happened at least once, and in this particular court that I can refer to, it's probably happened to other people. And so I know I'm speaking for at least one party, and I think I'm probably speaking for a lot of other people who may have faced this problem, but have not been able to figure out how to deal with it. And without this statute, this kind of behavior can continue. You know, one of the things that in more controversial subjects, there's one way that courts look at it, and it's called, this is capable of repetition, yet evading review. And that's an often repeated thing in prior U.S. Supreme Court cases. And this is clearly capable of repetition and evading review. I'll be happy to take any questions anyone has.
I'll start with a couple as I'm prepping for LSATs.
Okay.
The vodka example you used of impossibility, is that force majeure?
No, actually, it's not well, it could be considered it could be considered force majeure, but you either have subsequent illegality of subject matter or impossibility. So it could be, if the importation was banned, it might be impossible to do it. However, if it also became criminalized to possess Russian vodka, then it would be illegality of subject matter.
And force majeure is not legality,
it
it's
wouldn't
tort.
apply to
Okay.
that. Yeah.
Second question, when you say you prefer the word enforcement to contempt, because if I'm not mistaken, is contempt, one has to prove intent, and that is very difficult to prove, but enforcement is more discretionary and it's on preponderance of evidence. Do I have that correct?
They are flip sides of the same coin. Okay, so for example, in New Hampshire, there are lots of different definitions of contempt, but concisely put, the consensus in New Hampshire is contempt is usually basically a willful act. It's usually an intentional refusal to comply with a court order, or usually it's a refusal to comply with a court order. Okay, and there's usually a willfulness component to it. Previously, we talked about outlining the elements of contempt in New Hampshire in this committee. And the definition should be broadened, but it's going to be discretionary on the judge. And I have seen judges import case law, okay, from other jurisdictions in finding somebody to be a contempt. Okay, that's true. That's how much discretion is in it. And this needs to be done for predictability. I'm sorry if I'm talking beyond your point.
All right, having passed the practice LSAT for family law, I'm working on contracts next. Any other questions? Yes, Representative Grossman.
Thank you, Chairman Pearson, and thank you, Representative, for introducing this to us. So what, I guess in like layman's terms,
Sure.
how would this give the judge power now? They would be able to enforce, if you can describe now what would happen.
Okay, so for example, right now, a judge can simply pick up a potential contempt or similarly a motion to enforce, and bear in mind, enforcement doesn't necessarily have to have the willfulness of a contempt, and that's the difference I want to clarify, okay? In some jurisdictions, I'll muddy the waters just a little. In some jurisdictions, okay, a negligent failure to comply with an order is contemptuous conduct, okay? But in New Hampshire, we favor the willfulness. Okay, or the enforcement can be whatever. Okay, it just never got around to it. So you're not looking for a contempt; you're looking to enforce. So this would tell a judge, okay, this is the elements. Now, whatever is going on here, with the conditions precedent not being in the way, no duress, no undue influence, no particular change of circumstances, blah 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 blah. Okay, then the judge is going to have to look and say, okay, how do I enforce a remedy? Okay, how do I even create a remedy, which is what basically equitable jurisdiction is all about. That puts the party in their positions as they should be informed. Now, let's carry that this way, for example. Let's assume, for the sake of discussion here, that somebody is awarded stock rights in the context of a divorce. And let's assume that there is, and let's assume, for example, that the stock rights are being cashed in by the other party. Let's further assume that that party cashes in the stock rights and due to withholding on the stock units, says, okay, I'm giving you half of what you're entitled to. And you say, well, I'm entitled to the full amount that the court ordered me. And he says, no, it's withheld. But in the meanwhile, there is a remedy to be done, because what you can do, if you're in that situation, is you can fill out the appropriate tax forms, okay, which lets you deduct from your income the value of the money that you took. Okay? Now, if you bring this to a court's attention, why would a court refuse to enforce it and actually pay the party the money that they're owed? Court says, not going to do it. You're out. It's not reviewable.
Okay. Other questions? Yes, Representative Scher.
Thank you, Mr. Chair, and I wish you luck on the LSATs.
We rehearsed this.
Okay.
So I assume you're talking, there's two kinds of contempt in New Hampshire, criminal contempt and civil contempt.
Correct.
And you're talking about civil contempt?
Correct.
And in many jurisdictions, and I've only dealt with criminal contempt,
Okay.
not personally, but
Mm-hmm.
In many jurisdictions with civil contempt, the court has the power to either incarcerate someone for failure until they cure the contempt.
Correct.
Or to fine them for each day, each week, each month they don't cure the contempt. Is that the case in New Hampshire?
Yes. Basically, we do have civil contempt and criminal contempt. Occasionally, the lines blur. But generally speaking, in a civil contempt, the contemner holds the key to the jailhouse door. Okay, which means that is when you purge yourself of contempt by performing an act or doing whatever you're supposed to do, we're going to let you out of jail. And that's assuming the contempt is so egregious that the court's going to put the case on for a show cause hearing in New Hampshire, which is typically what happens as part of due process before they decide to make an incarceration decision. Criminal contempt, for example, would be more like what happened to Steve Bannon, okay, where he simply refused to comply with a subpoena and show up. Okay, there's other examples of criminal contempt, which I did an article on this for the New Hampshire Bar News last year, which preceded that bill, and I'm happy to provide it with you to give you the definition if you need it.
Follow up?
Follow up.
So in terms of enforcing the final property settlement, why isn't it effective for the judge to say, for every week you don't perform that which you're required to do under the property settlement, I'm going to fine you $1,000 or $5,000, or, set an amount like that, isn't that a pretty effective enforcement mechanism as it currently exists?
It would be, but it's entirely discretionary on the court, on the part of a judge, because remember, the power for contempt is entirely discretionary. What this does is that this makes an important distinction. You don't have to be found in contempt under this statute, a proposed statute, if it becomes law. All you need to do is be able to look to enforce a decree. So you can plead a contempt and the court can find one of two things. It can find that A, you are in contempt in the alternative and enforce it, or the court can find there was no willfulness here or it didn't meet the elements that the court would find relevant for contempt and simply enforce the decree.
And last follow-up.
Yeah, follow up.
So really, this comes down to, at least in the contempt context, comes down to, well, let me take that back and rephrase the question. Why not just take contempt out of it and just have, upon motion or petition by a party for enforcement? Why do we need to even have the words contempt?
Because they are flip sides of the same coin. And so a court can either find you in contempt, the court has so it gives two ways to plead a case. Number one is that if you don't think it's in contempt, the person pleading, the plaintiff or the petitioner in this case, doesn't think it's a contempt or doesn't think the court's going to find them in contempt, they can plead to enforce. Okay, and the court has and so that's why because there are two different causes of action within the law. You can seek to enforce your decree, which isn't necessarily contempt, or you can actually file a contempt and say that this is not only enforceable, but it is also contemptuous conduct on the part of the defendant or respondent.
Thank you.
Any other questions? Thank you.
Thank you, and thank you. I thank the committee. And by the way, if you look in your handout, you'll see the statute where it fits, and you'll also see what a petition for contempt looks like. Okay, and unfortunately, it is what it is. Thank you.
We're going to have a 5-minute recess, in which case Republicans stay in the room and Democrats follow the ranking member. And this is for the purpose of, are we ready to exec this bill? So I have no further cards. No. There are 4 doors exiting this room, and you may use any one of them, but use one of them. Go, go. I did not close the hearing. I recessed it. So we are back. Do you wish your questions to be internal to the committee or to the prime sponsor, which is effectively the same thing? Would you wish to ask further questions of the prime sponsor? Or would you like to ponder the questions and come back at another time when he will be here? Choice 2. Okay. So we're ready now then to close the hearing. Okay, I close the hearing on whatever this is. House Bill 320. Now, we've got an exact possibility here that the ranking member and I have discussed. Let me get my paperwork together here. How can I lose things so quickly? I open an executive session on House Bill 213, an act relative to wage garnishment for child support. And the question was raised to me from the ranking member about a fiscal note. Is that correct? That is correct. And I have made 2 copies of this. So when I'm done reading one copy, I'll let you take a look at it. I asked the budget office, legislative budget assistant, for where is the fiscal note, and this is an email to her from her, Melissa Rollins, to me yesterday at 2:23 p.m. Following up on your phone call, HB 213 has been determined to have no fiscal impact based on responses from the judicial branch and DHHS. DHHS indicated that any associated costs could be absorbed within their existing budget. So does that take care of the question? So are we ready to go? Good. I love it when a plan comes together. One second here. Crap. Wait. There we go. Chair recognizes Representative Seidel for a motion.
Thank you, Mr. Chair. I'd like to move HB 213 to OTP, please.
The motion is ought to pass. A wonderful colleague from across the aisle to second it. Representative Gregg is that wonderful colleague from across the aisle. The motion before us is on House Bill 213. Which is an act relative to wage garnishment for child support. It was moved by Representative Seidel and seconded by Representative Gregg. When the clerk is ready, please call the roll.
Chairman Pearson?
Yes.
Vice Chair Representative DeSimone?
Yes.
Representative Rice?
Yes.
Representative McMahon? Representative Nelson?
Yes.
Representative Seidel?
Yes.
Representative Love? Representative Corzine? Yes. Representative Markell?
Yes.
Representative Petrino?
Yes.
That's for you.
Representative Grossman?
Yes.
Representative Levesque? Oh,
Yes.
Representative Gregg?
Oh, yes.
Representative Raymond?
The part of Representative George is
Lucas? Yes. Thank you. Representative Malone?
Yes.
Representative McMahon? No.
Yes, President.
15?
16. The bill passes 16-0. It passed 16-0. You're not unanimous. Yes.
Representative McMahon didn't vote.
Yeah, so it's 15.
Okay, he was not present at the time the thing was called, so 15-0.
I did.
Would you like it on consent?
Which bill was it?
Any objections to it being on consent? It's going on consent. Going on consent, and Representative Seidel, if you would be so kind, please, as to have the committee reports ahead of time? Okay, or the blurb, either one.
Can you please pass that down to Representative Seidel?
And with this, I close the executive session on House Bill 213. I also believe ranking member said it would be okay, I think, to go to House Bill 243 relative to the, I open then the exec session on House Bill 243 FN relative to the penalty for false reports of suspected abuse and neglect made to the Division for Children, Youth, and Families. And the chair recognizes Representative Nelson for a motion.
Thank you, Mr. Chairman. I would like to pass this motion of OTP.
Okay, do I have a second? From one of you other folks?
I'll second.
I want to get a Democrat on it. I like to do that. No, you don't want to do that? No, no D, no D, no D, no D. They haven't. Okay, I saw a hand over here earlier, Representative Seidel. Discussion. Representative Rice.
So I cannot support this bill. I am too concerned about harm coming to children. So I will be voting no on the ought to pass motion.
How would you see harm coming to children?
I would see people being afraid to report abuse or neglect for fear it would be considered malicious.
Okay. Anyone else? Representative Petrino.
Thank you, Mr. Chairman. The way I read the bill, it seems that individuals who want to make an anonymous call can still do so. So if they have malicious intent, well, they can just remain anonymous. However, on the other end of the phone, the individual will hear that potentially there could be civil or criminal penalties for any kind of faults. And that may be chilling to some, and they may be hesitant to move forward. And that right there, I think, would potentially put some children at risk. And even if we're talking one child, that's one child too many.
Representative Gregg.
Thank you, Mr. Chairman. Just as I did last session, I have some pretty strong feelings about this bill, and I also understand the psychology of the people that are going to think twice about this, the conscientious people that are going to worry about, is this malicious? Am I doing the right things? Are not the ones that we would need to worry about anyway. People that have malicious intent, they're going to do this anyway because they don't care. They're already doing something that's illegal. Police reports and stuff, that's already illegal to file a police report. I also want to caution that we had testimony that the previous DCYF, what is that called, chair or whatever, so which was Joe Ribson, sat in here and said that he was okay with this. He did not. He actually sat in here and said, please don't pass this. The last time we had this bill, let them decide and decipher. They would rather get all the calls and not try to prohibit calls from coming in. We're missing so many already. Let's let them do their job that they're trained to do and decipher these calls without, letting the public know that they could be in trouble, because even the people that are not doing it maliciously, because of a good conscience and people that have the best intentions, they will think that twice. They will go, I don't know, and that will make it even more. So I know, because I've had to make calls before. I know that Representative Vice Chair DeSimone has also talked about her having to make calls. We're the ones that second guess this. Bills like that make those people second guess it more. Thank you.
Representative Raymond.
Thank you, Mr. Chairman. So for me, it really comes down to, because I've worked in a state that has this law, but we have the Office of the Child Advocate, who the legislature created to review how child welfare is happening in New Hampshire and advise us to the potential impacts of bills and how we can make things better for kids. And when the Office of the Child Advocate says that they're in opposition to a bill, I take that very seriously, because they are our first, they are our, I would say Overwatch, right? They're the people who are making sure that there's oversight. And so for me, if the oversight agency says this is not a good idea, then I tend to fall on this is probably not a good idea side.
Representative Schur.
I had a long conversation with the Office of the Child Advocate on a bill that was pending concerning child neglect in House Criminal Justice, Public Safety, and this piece of that bill didn't relate to this, but we got into the conversation about this kind of thing, and she was very persuasive to me that let's not try and criminalize too much when it relates to child neglect. Let's let the parts of the system, that is DCYF, handle that kind of issue rather than criminalizing it. And it was pretty persuasive to me.
Representative Nelson.
Thank you, Mr. Chairman. I'm sensitive to what people have been talking about, and I've thought a lot about this. I supported it last time, and I've done more research this time. There are false reporting penalties in most states, and some states have laws that include fines, and some states have laws regarding this that include prison time. We have red states and blue states alike who have laws that penalize individuals who falsely report. California, Massachusetts, Michigan, Texas, New York. And we heard during testimony that should New Hampshire create a law penalizing false reporting, that people would be less inclined and afraid to report actual cases of abuse, which are concerns here in this room too. But there was no data that was provided to those from those testifying to support that statement. And there was no findings that occurred in other states. So that is why I am in support of this. Thank you.
Since these comments seem to go very much to the heart of the bill, some things you can amend all you want, but that's usually on the edges. It seems to me that all an amendment would do would be to take this thing away. The choice really seems to me to be up or down. Anybody else? Representative DeSimone.
Thank you, Mr. Chairman. With all due respect to everybody who's spoken on both sides of this issue, I have called and reported, and yes, I did think about the ramifications if I was found to be just considered a troublemaker, but it did not deter me. I felt strong enough about the fact that a child could be being abused. I was ready to accept any consequences because I was calling on behalf of the child. So I
just feel that since there is no data to prove that it decreases the amount of legitimate callers on the issue, I can still support the bill.
Thank you. Representative Petrino.
Thank you, Mr. Chairman. So I know all of our towns have those Facebook pages where residents can kind of chime in. And so in Milford, we're no different. And just recently, somebody had posted, and I thought it was an interesting post. It said, "I heard a little girl screaming, and I'm not sure what to do because I don't think it's any of my business." And I was just floored when I read that. But 117 people at the time chimed in. And overwhelmingly, people were saying, you have to make a call. Call the police. If you're worried, you can be anonymous. And so this one particular issue was uncertain as to what to do. And I thought that was incredibly strange. So the bottom line is this. There are some people out there who are fearful to make the call. And if they know that maybe, you know, inadvertently, accidentally, they say something and there could be criminal or civil penalties, they may be hesitant. And that one hesitancy could put a child at risk. So, thank you.
I monitor the fire and police channel for my home city in Massachusetts, a city of 40,000 people. And all day I'm hearing police go to a certain place because a complaint has been called in. I don't see that we lack for it. I do know from talking to police officers in my hometown that there are people who do call in anonymously and make false reports. Their voices start to get recognized and eventually action is taken. But it is not on the basis of one citizen saying, that child is running around without a coat on, what's the matter with the mother? And then the cops come and discover, oh, it's Billy. Yeah, he does that on the school playground too. It's not the mother, it's Billy. And oh, mom was looking out the window and in the process of coming out. Where they move is if it is a very clearly false report from a person who regularly makes false reports. At that point, they make an action. They tell me they do not take an action on a sincere call. Fire departments get sent out because somebody saw steam and thought it was smoke. There's no penalty there. It was an honest mistake. And the police would make this same determination. It is when it is clearly malicious and repeatedly by the same person whose voice is now familiar that action is taken. I don't see that this would harm a child. I think that if a child is screaming and one person says, I can't call that in, somebody else probably just has or is about to. I also hear when police are dispatched to a certain place, the phrase receiving multiple calls. So I do sympathize for the concerns of those speaking against the bill, but I'm going to vote for it because I think the potential harm to people who are constantly complained against overrides the theoretical possibility one innocent child may be harmed by non-reporting. I don't think those are anyway equivalents. Anybody else want to weigh in? Yes, Representative Love.
Thank you, Mr. Chairman. Because we're making a crime of false reporting, wouldn't that crime have to be proven? You know, just to add a little more to what you just said, you know, we have to prove any crime that, and if somebody is constantly doing it, if there's a divorce going on and you know they've got 3 family members doing it, you know, you can put that all together and make a case. But if it's a mistake, you know, like someone mentioned a screaming kid, well, I'm sure the police or DCYF would rather go out and find out nothing's wrong than go out and find out that this kid has been abused. And I just think we're reaching here if we're gonna vote against this. I think this is a good bill.
And to say that the report was intentionally a false report. Intentionality is a fairly high bar to prove. So those people who make an honest mistake do not remotely rise to the level of intentionality. And in particular, when jurisdictions say there's got to be several of these intentional false reports, I think that is quite a high bar. Counselor?
Yes, thank you, Mr. Chairman. Yes, you're correct. Malice is basically the intent to injure. And so since you have to show the intent, a good faith error, you're not going to be able to prove that beyond a reasonable doubt in court. And I doubt law enforcement will bring an action on that basis. Once again, this is a matter of intent. And that malice standard is very high. It's a high bar.
Yes, Representative, please.
Just thank you very much. Just for clarification, the individual who's making the phone call, I'm wondering if they're aware of that.
Well, basically that's going to be from the intent, that's going to be from the surrounding facts and circumstances. Okay. And so, for example, I think the chairman correctly points out repeated instances, if they're targeted at the same person, things like that. Like I said, malice is a really high bar to prove criminally. Okay. This is not, don't confuse it with strict liability. There are very few strict liability, almost no strict liability crimes in the state of New Hampshire, save statutory rape. Okay. So that would be a high bar. And not only that, we don't even have to deal with a rebuttable presumption here. So I think you're safe if you vote this. And I think it won't probably deter somebody who was hell-bent on malice, but it probably would provide relief for somebody who was the victim of repeated false offenses. So I can support this.
Representative Rice.
Thank you, Mr. Chairman. So I'd like to point out, though, that on page 2 of the bill, line 5, you have the ability, it's already in law, to bring a civil action against someone for maliciously reporting. That is already in law.
Yes, but this criminalizes it. That's a different standard. And civil liability is preponderance of the evidence in most cases, where this is beyond a reasonable doubt.
Follow up?
It's the criminality that I worry about, those that is going to prevent people from calling. People who want to do malicious reporting can still do it anonymously. And you have no way to find out their information because they're not giving it.
Well,
it's my concern is the people that it's going to prevent from calling.
I guess with all due respect, if I may respond, Mr. Chairman, I think that's going to really depend on the level of the sophistication of the actors. I think police, when you call the police, I think the phone number comes up unless you've got a block on it or whatever. But I think the chairman correctly points out that when they get numerous multiple calls, they're able to figure out what's going on.
I doubt somebody making an honest mistake would use a burner phone to make this call.
Correct.
Representative? Sure.
Being a law professor, I always try and do.
Could you stand a little closer to your mic, or could you put your mic a little closer to your mouth?
Being a law professor, I always resort to research in the absence of knowledge. RSA 641-4 already criminalizes as a misdemeanor false report to law enforcement. So I'm just not sure we need, putting aside all the other arguments that have been made on both sides, I'm just not sure we need this because of RSA 641-4.
Do you have it handy up on your screen to
I do.
read to us? Because I don't want to walk to the back of the room and look it up. Thank you.
I can read it if you
Please.
want. Okay. A person is guilty of a misdemeanor if he, 1, knowingly gives or causes to be given false information to a law enforcement officer with the purpose of inducing such officer to believe that another has committed an offense. Or 2, knowingly gives or causes to be given information to any law enforcement officer concerning the commission of an offense or the danger from an explosive or other dangerous substance, knowing that the offense or danger did not occur or exist, or knowing that he has no information relating to the offense or charge, or the offense or danger. What strikes me about this is particularly the second paragraph has a knowingly mental state rather than a purposely mental state or a malicious mental state, which is easier to prove. You just have to know that you are reporting something falsely. So I think there is not perfect overlap between this and what's proposed, but I think there's enough overlap that it concerns me that this bill concerns me in that way.
So it would be your testimony that, or your observation that 641-4 pretty much covers what this bill is trying to do?
It covers much of what this
Much
bill
of
is
it.
trying to do. It's again, it's not a perfect overlap, but it's a significant overlap.
All right, to give you a leading question, then 641-4 would cover much of the intent of the bill without the possible harm that people have spoken to, in your opinion? That was a leading question.
Yeah, which I didn't understand.
Oh, good.
But
In other words,
I'll answer anyway if you
of
want.
course.
Now, rephrase your question, please. As the judge would say.
Existing law covers most of what the bill wants to do,
Yes.
but existing law doesn't have the little negative that people have been observing about the bill as a
Correct.
deterrent of some people calling.
I think this functions as enough of a deterrent that we don't need to have a whole separate statute. I tend not to be a big fan of plugging little holes as opposed to plugging big holes, and I think this is a plugging a little hole given the existence of 641-4.
Okay, Representative DeSimone.
Thank you, Mr. Chairman. The representative's discussion concerning, was it 641? That, the only thing that concerns me about relating the two is that 641 specifies to police. In a court of law, if a person is suing another person for falsely reporting to DHHS or DCYF, it could be argued that 641 only specifies police and does not include DCYF or DHHS, and it could deter the court from making a determination in that case. Does that make sense to anybody else?
Yeah, Representative Markell.
Yes, I appreciate fellow counsel's comments. The difference here that I see, I echo what Vice Chair says about reports, not other than law enforcement. But without this, what you do is you're able, I think you're able to raise reasonable doubt about your actions if you're going to be able to have conflicting statutes on point. So in other words, assume for the sake of argument that law enforcement brings an action based on 641, okay, and says false reports. I've had those cases. Now all of a sudden somebody asserts that they are immune from criminal prosecution because no, I was dealing with child abuse. And this is a false report, but what you're doing is you have two problems. First of all, I'd be making an overbreadth argument, particularly where I have conflicting statutes, one which immunizes me, okay, because I'm making, absent this statute, I'm making a report about what I suspect to be child abuse. Whatever my true motives are, I'm going to conceal from the police. But all of a sudden, when confronted with a motion to dismiss I'm going to have to say that I don't think you would be able to prove your case beyond a reasonable doubt, because I'm going to assert immunity from liability for a report I made to law enforcement, also DCYF. So if I'm calling DCYF and not law enforcement, the statute's going to be, if it goes out the other way, I think you're looking at a constitutional issue about overbreadth and criminalizing whatever the conduct would be. That's how I'm looking at it. So I think you got, I think you have, I think it, I would agree with the chairman. I think it does no harm. I think it probably helps rather than hurts, and it probably, so that's just my view.
Having heard defense counsel, prosecutor?
Boy, that makes me nervous. In a sense, with all due respect,
Yeah.
I think you make my point. Conflicting statutes create more of a mess than one statute.
Well, then that would be the point of criminalizing it under both statutes. So in other words, I have a client who comes in and says, help, I've been charged with making a false report to a police, RSA 641, whatever. Okay, and I'm going to say, who did you call? And you called the police. Why? I suspected child abuse. Okay, and Your Honor, motion to dismiss. My client is subject to immunity for making a good faith for making a report. Case can't be proven beyond a reasonable doubt. Number one. Number two, the historic purpose of criminal justice is my right to raise a reasonable doubt about my client's guilt. And I think a court's going to have to come down on that, and I think I'll get a dismissal on that basis, respectfully put.
Wow. And Aaron Cregan said if I was a lawyer, I'd be an appellate judge. I'm going to reconsider that. Well, there it is. Motion before us is Youth and Families. Motion OTP by Representative Nelson and seconded by Representative Seidel. If you are for the motion OTP, you will vote yes. If you are against, you will vote no. Clerk, please call the roll.
Chairman Pearson,
Yes.
Representative DeSimone,
Yes.
Representative Rice,
No.
Representative McMahon,
No.
Representative Nelson,
Yes.
Representative Seidel,
Yes.
Representative Love. Yes. Representative Corzine, yes. Representative Markel,
Yes.
Representative Petrino,
No.
Representative Grossman,
No.
Representative Scheer,
No.
Representative Gregg,
No.
Representative Raymond,
No.
Representative Lucas,
No.
Representative Malone.
No.
Seven to nine.
The motion fails 9-7 against the bill. Is there another motion, a positive motion that would like to be made? What? I'm sorry?
7 to 9.
And 9 against. If I'm correct now, I can entertain an ITL motion.
I make a
Mr.
motion to
Representative Petrino.
ITL. Thank you, Mr. Chairman. I move ITL.
And seconded by Representative Rice. The motion is to ITL House Bill 243 FN relative to the penalty for false reports of suspected abuse and neglect made to the Division for Children, Youth, and Families. The motion is ITL, made by Representative Petrino, seconded by Representative Rice. If you are for ITL, you vote yes. If you are against ITL, you vote no. And a chair can call the roll, please.
Chairman Pearson,
This time, I am going to vote yes again.
Chairman DeSimone, Vice Chair, sorry.
No.
Chairman Rice, Representative, sorry.
Woo, flashback.
Representative Rice,
Yes.
Representative McMahon.
Yes.
Representative Nelson.
No.
Representative Seidel.
No.
Representative Love.
No.
Representative Corzine, no. Representative Markel.
No.
Representative Petrino.
Yes.
Representative Grossman.
Yes.
Representative Scheer.
Yes.
Representative Gregg.
Yes.
Representative Raymond. Representative Lucas.
Yes.
Representative Malone.
Yes.
The ITL motion passes 10 to 6. And if Representative Petrino would write the committee's report. And I'll tell you a story about when somebody whoopsed and voted the wrong way. It was during the old days of COVID. And some of you remember Representative Snow from Manchester, Kendrick Snow. He was a rep for a long time, and he was a social worker in Manchester for 40 years. And we were all remote except for me, who was sitting in a chair somewhere, and called the roll. And we could look up and see him asleep. Remember, this is all Zoomed. And I stopped the voting and I asked Representative Weber, call his wife, wake him up. And you can see in the picture, she's running, hey, Ken, wake up, you gotta vote. I vote yes, which he didn't mean to. And you heard groans from some and cheers from the other. We got to the end, and I said, the chair will entertain a motion for reconsideration. We passed it unanimously. We did it all over again. So every once in a while, for purposes of sleep or what have you, it's easy to vote yes when you really meant no. So there's my story. I'm sticking to it. 10 to 6, ITL motion passes, and this will end our exec session on House Bill 243. Thank you for the spirited discussion. Now, what did we do with the previous one?
I have a question for the chair, not related to the LSAT. If I need to leave by 10 of 12, I don't know if you're going to exec anything more, but I don't want to, you need
to leave by 10 to 12. We've got 10 minutes more, or 20 minutes more of your company, but we're done for the morning. We're not going to exec anything else.
Looking at the pained expressions on most people's face when I talk, I'm not sure they want 10 more minutes. The second question is, I can be back. I have to testify in front of House Transportation at 1:20.
Come in and out as you feel like.
Are you going to exec bills this afternoon?
We'll see. I mean, if they're ones we don't, if we are pretty much of consensus, do we have anything more we're likely to? We've got 350 and 335.
Then I will be back this afternoon as close to 1:45 as I can.
Okay, yeah, we can, I mean, we really do try to play fair with each other here, so.
Thank you.
And if we're going to exec and it's going to be that close, I doubt if the bill is going to be that close, we would exec it, because if it's that close, at least one group, if not both groups, want to do some more thinking and arm twisting and whatnot, but.
Thank you, Mr. Chair.
Are we going to meet again on mental health court stuff?
Yes, I would like to.
I would too.
Maybe after you're done this afternoon. Is that too soon, or?
It would be too soon for me, but
Okay.
I'm thinking.
Then
that-
I'll reach out to you.
Okay, let's do that. Thank you.
Okay.
I'm just going to go first because I'm sorry,
Yes.
but I'll come back.
Thank you.
It's here.
Thank you.
We'll be back by about 1:15.
All right.
11:30. Our next bill is at 1 o'clock.
Oh, I gotta leave. Thank you for reminding me. I gotta be.
We can be back by like 4:15 and let everybody who's already gone know.
Why?
No, the whole committee, then we can kind of.
My practice is concentration in defense and some still. Chairman, I'm very happy to be here. Thank you.
So this is my first term. I have been in foster care when I was a young person, and then I became a foster parent as an adult. I have 2 of my own adult children that were either still in their lives, or I have another one that for are still experiencing and how they're getting stuck. And then it just sort of goes from there. I'm just that person that children, prevention, preventative of abuse, of any type of abuse for children or other humans is super important. And I'm wicked happy to be here.
Okay, I have to put the mic on so everybody who is watching this live stream can hear. Children and Family Law is the best committee in the entire state. Thank you, everybody who's serving.
The chair wishes to thank Representative Grossman for her French fries at lunch. Well, you weren't eating them.
See how giving she is.
Yeah, the first one I stole.
Okay, Mr. Chairman.
Do we want to talk about this? We got 3 minutes to go.
That's
No,
your
wait till-
prerogative. You're the chairman.
We can wait to the end. Okay. Just a word or two, because there's been a lot of confusion over the issue of constitutionality. And we heard at chairs and vice chairs meeting this morning the policy. The vice chairwoman has her vice chair's guidebook, and in it, it says, one of your duties is no committee shall report with a positive recommendation any bill or resolution which would, if enacted, be a violation of any article of the Constitution of New Hampshire or of the United States of America, or grant broad rulemaking authority to an agency or department. The vice chairman or another member of each committee shall review all pending legislation and shall advise the members of all legislation before the committee, which should be reviewed in terms of this rule. Her review statement to me is advice. It is not a ruling. And when I forwarded that to everyone, it is advice. The chair can make a lot of rulings. This is not one of them. I do not rule on the constitutionality. The presumption is that any bill that comes before us is constitutional. If the vice chair or the chair say, don't think so, that is a personal opinion, not a ruling. When we come to exec the bill, if you don't think the bill is constitutional, then you should vote in the negative. If you do not think it's a problem, you can vote either way, whichever you wish. Where this is challenged initially will be the Speaker's office, and we will talk with the Speaker if we have some concerns. After that, the people who rule on the constitutionality of something is the courts, not here. So therefore, the chair will not entertain anybody saying, well, you've got to stop this because it's unconstitutional. I cannot make a ruling that way. I can go forward, and if I happen to agree with you, I'll vote no. Did I miss anything?
No, Mr. Chairman, I don't think you have, but I will tell you that Mr. Chairman has made sure that he has more than once asked me to make sure that any legislation that comes before us is, in my opinion, constitutional. I have yet to find a piece of legislation that has come across our desks that I have an opinion that it could be deemed unconstitutional. But I just wanted to reiterate, we as legislators in this room take an oath to uphold the United States Constitution, the state of New Hampshire's Constitution. Those two constitutions we follow. The next thing we follow are House rules. And then after that comes the laws that we make, and the laws that we amend, and the laws that we change. That's how we are to run our legislative lives, and that's to the best of their ability. And we work together as a team. Thank you, Mr.
Reasonable
Chairman.
people, however, can have differences of opinion as to whether a bill is constitutional or not. So I reiterate, she does not make a ruling. I do not make a ruling. I will continue with any bill that has been given to me. I will not stop. I am not allowed to stop. When we exec a bill, that is when the question of constitutionality can be raised by individuals. And an individual believing it is unconstitutional should vote no. Others may vote however they like the bill or don't like the bill. After that, it is out of the committee's control. So I would please ask people who come to testify, you may state your opinion. However, your opinion is more likely to be believed if you can point specifically to where that question in either constitution is raised. If you make a broad statement saying it's unconstitutional, you will convince no one. But if you can point to a certain line item, then it is up to each one of us to decide, have you proven your case? You say this line in the Constitution and this bill are at odds. It will be up to each individual to decide whether that's true or not. So there it is. And everybody up and down the line apologizes for any confusions. I will have to leave partway through, about 1:20-ish, because I am introducing two of my bills in the Muni County Committee. Then I'll be back. With that, the chair opens House Bill 350 FN, a hearing on a bill requiring that all family division hearings be video and audio recorded and broadcast live. The chair recognizes Representative Caitlin Katab, who is subbing for the prime sponsor, Representative Post.
Thank you, Chairman Pearson and members of the Child and Family Law Committee. For the record, my name is Representative Caitlin Kutab, and I am here to introduce this bill for the prime sponsor, Lisa Post, who could not be here. When this bill was initially introduced, the purpose of the bill was to provide transparency into the family court proceedings and to have audio and video recordings of the non-confidential proceedings in the family division. However, after it was implemented, I worked with Rep. Post to talk with the court about it, and there were really quite a few concerns with it. And so we'd like to work with the court to potentially amend this into a pilot program instead. And I want to give some specifics on what those concerns were. So, for example, there might be private bench conversations, and there is no staff in many of the courtrooms that are available to mute the microphones, and we wouldn't want those private convos to be recorded. And also, you may have pro se parties in the family cases that may reveal some of their child's private, confidential medical information that we wouldn't want to be included. And with 32 court locations, there aren't staff in each of those courtrooms. So the purpose of the pilot program would be to see how often these are requested, how difficult is it for this to happen, test out the equipment that might be used for it to see, does this equipment work well? They would likely have to do some sort of potential redactions as these are requested if there were to be confidential information revealed within them. So we're still kind of trying to work through what might work. So if possible, I'd like to request if you guys could not exec the bill yet, to give a little bit of time to try and work together with the court to see if there's a potential pilot we might be able to recommend.
Because this is an early bill, we've got to get it out the door here on March 6th. So for your scheduling purposes, we would probably exec it on the 6th. The previous week is New Hampshire school vacation week, and we're pretty well booked up for the next couple of weeks anyway. So if you can get it here by March 6th, we'll take a look at it.
Thank you. Free to take any questions. Thank you.
I've already heard some questions on this and aren't hearing them now. Okay. Chair recognizes Representative Erica Leon.
Thank you, Mr. Chairman. For the record, my name is Erica Leon. I represent the town of Derry as well as a couple of the members of this committee. So I'm glad to be in front of all of you today. I am a co-sponsor of this bill because right now there's not a lot of confidence that everything that happens in the courtroom actually makes it to the record. I had a family contact me stating that their parole officer had testified that they had actually come and visited a child right after they had supposedly assaulted the child. The parole officer came in, spoke in the courtroom, and that never actually made it into the record. There's been a number of times where what we hear from people isn't the same as the record, and we need to have a way to determine what is true and what is not. Right now, we're stuck in a lot of he said, she said. I know that that's something that this committee deals with a lot, but I think it's absolutely critical that that there is able to be a record made of the proceedings that's not subject to the same human error that minutes can be subject to, because we're talking about families and we're talking about people's children. We're talking about potentially having exculpatory evidence that is heard and stated in the courtroom, but is not entered into the record, leaving children separated from their parents when there really is no good reason for that to happen, because somebody has come in and said, no, I saw that child after that incident. And there's somebody that the state and the courts trust because they are a parole officer. So I'm interested to see what Representative Khattab has done with this bill. As a co-sponsor, I hadn't heard anything yet about this. What I do want to do is make sure that we have the information and we can stop this. We can stop trying to have to resolve these disputes when people's children are taken from them without as much information as those families want to make available to us. Because if they choose to have this information recorded, they're already willing to have it known that the state's trying to take their children from them. They're already ready to have it known, all of the awful things that will be said in those hearings. And they think that it's important enough to be able to do that publicly, so that they can make sure that justice is served. And I think that we owe them the ability to make sure that what is said in court is what's recorded in court, and that children aren't separated from families unnecessarily, and also that families aren't kept with parents who are causing harm either. This goes both ways. We need to make sure that we are prioritizing the children, both in their safety and in their security of staying with loving families. So with that, I'd be happy to take any questions.
Representative Rice.
Thank you, Mr. Chairman. Thank you for taking my question. Nowhere in here do I see a time limit as to how long the judiciary is supposed to hold on to these recordings and then determining how long they have to hold on to these. Do they have the storage capacity to keep these? And how much more is that going to cost us?
Well, thank you for those questions. They're very good points. And since it looks like there's an already amendment in the works, that would be good to make sure that we include in this as well, however it moves forward. And I appreciate you raising those concerns because those are important.
Thank you.
Representative Petrino.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. I'm just curious as to the rationale behind the live broadcasting of the proceedings.
Thank you for that question. We also have the issue where if somebody's able to watch, then they're able to see what's going on. It's always a challenge to figure out how to do this, but if a family wants to say, this is what's happening to me, I want to have eyes on what is happening in court, that's why you would have a live broadcast. As you know, here we do have a time delay. So I'm sure that I would expect that this would be subject to administrative rules. Assuming that DCYF, I guess this isn't DCYF, but I actually couldn't even find the DCYF administrative rules, which is troubling. But this would be subject to administrative rules, and by doing that, they would be able to have something like perhaps there's an emergency pause button, just like security has here. If something goes wrong with the recording, that there may be some times when they say, well, we need to stop this ride right here. And I would be amenable to that idea, being able to pause something if something truly potentially harmful is happening, but also where it continues along.
Representative Rice.
Thank you, Mr. Chairman. Thank you again for taking my question. So these hearings have a lot of confidential information. A lot of times they have to do with children. And I'm just concerned that live broadcasts or information to the public out there could cause a child irreparable harm, especially by classmates or, their peers that sees this going on and then they're getting backlash. How would we prevent that from happening?
Well, thank you for the question. I wish we weren't in a position where we needed to have this. Right now, we also have the irreparable harm of having children taken from their parents when there's exculpatory evidence presented in court saying that the allegations cannot, in fact, be true, yet that child is still separated from their parents and from their family and from their support system, and sometimes even from their schools. I wish we weren't at the situation where we're looking at live streaming these court cases, but families are being failed on both sides of the coin, both when children are harmed and when children are taken needlessly, because that causes harm too. It's not a perfect solution, but neither is taking a child when they should not be taken from their home.
Representative Corzine.
Thank you, Mr. Chairman, and thank you for being here. I hear you saying that this will be an opt-in type of situation and not necessarily recording every single case.
Thank you for the question. As I was looking, that was my understanding as we were working through the language of the bill, that this would be on request of the families, because if this isn't on request of any of the parties involved, then that would be a huge violation of privacy. However, allowing a family to opt into that is what my intention was in co-sponsoring the bill, and that was language that I had reviewed. It's possible that I had read the intentions more than what the language was, but I in no way intend for anything to be made public unless somebody is standing there and saying, I want this to be broadcast because I want people to know the truth of this process.
When I look at lines 12 and 13 of the bill, the family division shall broadcast live if requested to do so by the plaintiff or defendant or named representative. That sounds like one party can request it and it will be so. I don't see that this means if one party objects, it shall not be so.
Thank you for finding that section. And then if you look below that, it says the presiding judge shall grant the request unless the opposing party representative shows by a preponderance of the evidence that the broadcast is more likely than not to cause specific irreparable harm to a party or witness. And upon that showing, then they wouldn't show those parts that would cause harm, and that the judge will state the basis for that.
But that person has to prove preponderance of evidence, is what I'm reading.
I think that it's important to have some sort of guardrails, because if you were able to say, I think that somebody might bully this kid if they find out that their family's in family court, and right now you have a family that's trying to stay together because of potentially false allegations, and they have somebody in order to dispute that with very clear evidence, especially somebody that it would be normally respected by the court, that the other side shouldn't be able to silence that just because they don't want that part heard. We're in the situation where very well-intentioned people are trying to do the best they can for families, and families are trying to also keep themselves intact. There will always be emotions. There will always be personal feelings that come into play, as much as people try and stay neutral and unbiased. And because most of the people involved in these family courts and in this really, really, truly want the best for these children, they may sometimes not see things the same way as another person would or another party would. So having the judge specifically say why something won't be broadcast will give us much clearer guidelines around that and have that transparency.
Representative DeSimone.
Thank you, Mr. Chairman, and thank you for taking my question, and thank you again for coming here today. This bill talks about recording and broadcasting the proceedings. To whom will these proceedings be broadcast?
On lines 19 and 20, the link to the live broadcast shall be available to the public through the clerk's office at the location where the proceeding takes place.
Follow up.
Thank you. Will you take a follow-up?
Yes.
Thank you for taking a follow-up. In that particular case, that it's going to be broadcast to all of those people, if a person who is to be cross-examined by one or the other attorney, and that person says, I don't want my testimony broadcast, what happens then?
Well, thank you for that question. The point is, we're trying to make sure that children are only removed from the families for good reason. When you're looking at this, if they're already testifying, then that's already known that they are testifying. The question is, why would you not want to have your testimony shared if you are truly speaking on the best interest of the children and best interest of the child? Because we understand that there's judgment calls that come into play, but transparency around this is very important, and that helps for other people to understand where that line is and understand what is and isn't acceptable.
Representative Gregg.
Thank you, Mr. Chairman, and thank you for taking my question. So understanding the sensitive nature of family court proceedings, also understanding the fact that sometimes people who are complicit in abusive behaviors don't understand that. What the judicial branch has is a very specific thing that's very case specific. And I worry about I worry about the two branches here. We are the legislative and they're the judicial, and they are in the trenches covering each one of these cases. Has it been thought to bring this to the judicial branch to maybe do what other states do and have, it's kind of like when you're a student teacher or something, they have somebody sit in and observe the judges to see what's going on, and it's a surprise. So it's kind of like an audit, they don't know, but that actually examines what each judge is doing to help with that judicial oversight versus the legislature trying to get involved in the judicial branch and telling them how to mitigate very sensitive situations.
Well, thank you for that idea. That is also another interesting approach. I do have to say that just because you want to have something happen in public doesn't mean that it's always comfortable. TSA, when I've had to be searched, and even in areas that I don't want to, I don't go into another location, even if it might expose a little bit more of me than I would like. I would rather have that done in public, just because sometimes it feels better to make sure that there are other eyes observing what's happening. We're all working the best that we can in order to implement the laws and pass the laws that are most protective of everybody who's involved. However, we also need to make sure that power balance as well is not leading to a point where families are losing their children when they shouldn't. And also that when people are able to see those power balances when somebody is enabling this sort of abuse, I think that people understanding that, Mrs. Jones actually was doing the wrong thing. Mrs. Jones was having it so that her child was being subjected to harm, and by Mrs. Jones not standing up to that, that is truly harm. While somebody may not intend to make themselves an example of what not to do, that's what happens when you choose to have something done publicly. And when people are able to see it, it's a lot easier to say, no, that's not, you may think that this was wrong, but in fact, what you're doing is something that is not acceptable to people in New Hampshire. It's not an acceptable way of raising your children, and that is something that we all see as abuse. And once you get to the point where that can be broadcast and that can be shared, then you get past the question of, well, do I trust this person? Do I trust what they're saying? Because so much of this dispute comes down to who we trust.
Follow-up, Representative Gregg.
Thank you, Mr. Chairman. Would you believe that I've sat in on many, many court cases and watched the high level of emotion and watch people say things or do things that they wouldn't normally do in public, that had that been broadcasted, they would probably struggle to then find a job or anything else after?
Well, that was a would you believe, right? That was a would you believe. Yes, but I also do know that there's people who massively struggle with having their children taken when there's not a good reason for it. And you and I sat in the subcommittee on DCYF, and we did hear very emotional testimony. Some that I also saw was getting into that emotional area. But the question is, if people want to have views into what is happening and why their child is being removed, I think that that is reasonable.
Thank you. Representative Raymond.
Thank you, Madam Chair, Vice Chairwoman, and thank you for taking my question. My question is about the rights of the child to privacy. I'm thinking about the hundreds of cases in the family court that I've sat in where therapeutic records, where medical records, and where evidence of things like sexual abuse have been discussed in the courtroom. And my question is, who gets to decide where the child's right to privacy is? And if the parents disagree on whether or not they think it's a good idea for their minor child's information to go out, where's the protection for like the best interest part of this bill? Because I'm seeing preponderance of the evidence that it would hurt them, but where's the best interest that is usually guides most of our stuff?
Well, thank you for the question. I would support giving a veto of that child of saying that I don't want any of this broadcast. But if the child is sitting there saying, why am I not able to see my dad? Why was I removed from the home? Why is this happening? Because my dad hasn't done anything to hurt me, and they don't understand why it's happened, that child should be able to say, no, I may only be 7, but I know that my dad didn't do anything wrong, and I want this to be broadcast to make sure I can get back with him. You know, if you give it to a veto power of the child, then we get into a situation where, at least in some of these cases, we can be in a situation where we're not separating these families. Honestly, I think that that might make sense, because I do agree that you don't want to have your dirty laundry tossed out in public unless there is a very, very strong reason to do so. But I have spoken with people where it does seem very clear that there was a violation, and if they had been able to have a recording and have that information, I think that everybody would see how clear it was, or I would know that the wool's been pulled over my eyes. But either way, somebody who wanted to make that public, we would understand what was happening.
Thank you. Representative Rice, and then Representative Nelson.
Thank you, Madam Chair. Thank you for taking another question. So in Section 4 of the bill, it states copies of video and audio recordings shall be made available by the clerk's office, blah, blah, blah. So anybody can just go in and grab the video of the private and personal hearing that was just held that may not have anything to do with the family? Because there's no limitations here.
Thank you for bringing that up. That would be a good limitation to add. So I appreciate you helping make it better. Thank you.
Representative Nelson.
Thank you, Madam Vice Chair, and thank you, Representative, for taking my question. Are there other states who are where this is in practice?
Thank you for the question. I don't know. And thank you, Madam Chair.
Representative Grossman.
Thank you, Madam Chair. Thank you for coming here today. So divorce proceedings, family court, it can already be contentious. In situations where the two parties don't agree, what would occur?
If you look at this, it says that if one party asks to have that, then the judge would need to say that there's irreparable harm.
They would need to prove, right? So it would be another, they would first need to prove it, and then the judge would order it?
Thank you. Yes, I can read that that's what's in here, and I do know that there is an amendment that is coming. So since there is an idea of an amendment, assuming that it sounds that the amendment was supported by the prime sponsor. So if the prime sponsor has an amendment, then I think that it's helpful to highlight some of the issues and challenges with this language so that she can incorporate this into her amendment. But and I thank you for highlighting that.
Look forward to the amendment. Thanks.
Representative Love?
Thank you, Madam Chair. Thank you for taking my question. You mentioned that the probation officer had gone to court and testified, and somehow that testimony came up missing. Would you, and you know, there's a lot of opposition to the privacy of people here. Would the sponsors be amenable to amending this to just, it shall be recorded and those recordings are available to the parties?
Thank you. That is an interesting idea where then if that is available and it can be referenced, that may be one way to address the privacy concerns.
Any further questions? Representative Markell?
Thank you for taking my call. Question, sorry. Nobody's perfect. Out of curiosity, you're aware that audio recordings are made of these proceedings as they go, correct?
Correct. I am aware that we did pass that. The part of the question, I think, I am aware that we had passed that. My question is that there's also been issues with the audio recording seeming like they've been cut off from time to time. I've heard that before. I'm more giving that general information of it because if you have a video recording, it's a lot easier to see the stutter step if the video goes out as opposed to an audio recording going out.
Okay. Follow-up question? Follow-up? Thank you. Because you can order, in my experience, also ordering them for appeals, is that when you in New Hampshire, you contact e-scribers and you can order an audio recording of it, and you can also get a written transcript of the proceedings. I guess what I'm trying to understand, if there's going to be a break in the audio, there'll be a break in the transcript as well, wouldn't there?
Correct. And that is actually one of the issues that having a video recording where you can see if suddenly it goes from me speaking here and then it starts again with me sitting in the other chair next to it, it's clear that is not a continuous recording. In an audio recording, that's not the case. I'm not trying to claim malfeasance. I'm talking. Thank you. That actually, I was about to say that I'm talking about when there's technical problems and nobody is intended to cut off, when nobody is intended to cut off the recording, but it happens from time to time because we're all human, and worse, we use computers and they don't always like us. So sometimes there's unavoidable reasons why there is a break in the continuity. And that doesn't mean that somebody's doing something wrong. It just means that there's a break in the continuity.
Okay, thank you.
Representative Rice?
Thank you, Madam Chair. Thank you again. So my next question is going to be, what prevents someone from getting these recordings with the children in the thing, and then they're posted to social media and all that? Is there going to be limitations as to what they can do with these recordings?
Well, thank you for the question. I think that is a very good idea to it's a matter of putting the guardrails around that. So nobody was allowed to even speak about their case in DCYF until recently because there was a gag order on some of what was happening. So we do have some of those issues around that transparency. And I know we're all working together to better improve the lives of both children and families, and there are some hurdles along the way. I don't think that this should be shared maliciously on social media, but I also think that if you have video that your parole officer saw your child 5 5 minutes after you supposedly punched him in the face, and the parole officer says, no, I visited them and they were fine and they were watching a movie at the time and nothing was wrong. And if you still have your child taken based on testimony that's put against, that has a parole officer testifying on your behalf, at a certain point, shouldn't you be allowed to share that on social media? I would hope that we aren't having things like that happening. I'm kind of hoping for the recordings so that I can know if somebody is selling me a bill of goods. But if this is actually happening, that's a huge problem. It's a huge silent problem, and it's something that we can address through greater transparency. And I appreciate all the work you've done trying to keep kids safe. I really do.
Seeing no further questions, thank you for your time and testimony.
Thank you.
Next, I'll call Mary Kruger. Mary, you've asked for 5 minutes. Welcome.
Thank you, Madam Vice Chair, and thank you, members of the committee. My name is Mary Kruger. I'm an attorney with New Hampshire Legal Assistance. We are a statewide civil legal services program helping people in poverty with various basic needs. We operate our domestic violence advocacy project, which I supervise, and we represent high lethality victims of domestic violence, sexual assault, stalking in protection order cases, divorce, and parenting cases. We're asking that this committee inexpedient to legislate this bill. And I have prepared written testimony. I apologize that I did have some issues with the copy machine, so there's blank pages interspersed throughout, whereas I was trying to double page, so I completely muffed it up, and so forgive me for that. But you'll see that there are really 3 main reasons why we would oppose this. One, we believe it will harm children who are already negatively impacted when parents are separating. And I'll point out that we just heard a lot of testimony about DCYF proceedings. When I read this, it hadn't even occurred to me that that was an intention, was to broadcast live confidential DCYF abuse and neglect or termination of parental rights cases, which are already confidential cases under statute, and this specifically excludes confidential cases from being broadcast if this were enacted. So it would not even fix the situation that we just heard about, because those would be excluded entirely. So I read this to apply to divorce, parenting, and protection order cases in the family court. And when I see that, I do see that one party could decide to request to have it live streamed. There's no guardrails whatsoever on that. And the limitation that's placed on that, where by a preponderance of the evidence, the other party who doesn't want it live streamed would have to demonstrate irreparable harm to them or a witness. And then the court would need to decide which portion of the case would not be broadcast. So this would be broadcast live streamed. Anybody could download that broadcast. It's going to be there really forever, right? It's out there on the internet. There's no hauling it back. I also think even if the court didn't grant the request to live stream, when we have the video recordings, it just makes it that much more easy for someone to go request that video recording and then take pieces of that videotape and post selective cuts on TikTok or Facebook or Instagram or you name it, whatever, YouTube, social media that you can think of. And it's gone. It's there. It's out there. I do think that that is a major concern, especially for kids, because they are already, by the policy of the family court, the court is trying to set a stage when parents are separating to protect children. The first thing that families do is go to a first appearance, and you probably all know about this, but this is the opportunity where the parents come, hear from the judge about how to behave in the best interest of their children to try to work towards co-parenting. Every single parent has to go to a child impact seminar. That seminar is I think it's like 3 hours that they sit and they learn all about how to be thinking about their children's best interest as they separate, to try to calm things down. Children should be protected from what happens in the courtroom. Children will not be protected from what happens in the courtroom if this bill passes.
1 minute.
And then the last thing is, I think that for domestic violence survivors, this will be a barrier to wanting to file protection orders because they will be concerned that this could be live streamed. This will be a threat that could be held over their head to not go seek the help that they need. There's several ways that an abuser could coerce a victim if this were enacted. So I just want to reiterate that we're asking this to be ITL. I can't believe that the court would want to pilot this. Honestly, I don't think that's an amendment that we would support either. Thank you.
Thank you, Ms. Kruger. Any questions? Seeing none, thank you for your testimony.
Thank you.
I'll call forward Mr. Dana Albrecht. He asks for 3 minutes. Good afternoon.
Good afternoon, Madam Chair and members of the committee. For the record, my name's Dana Albrecht. I have 3 exhibits that are being passed around. The first is an email from eScribers regarding the preparation of a court transcript where they're going to deliberately leave out judicial misconduct. And eScribers tells the judicial branch, quote, "Of course, we are not going to just transcribe that. However, the ordering party has also ordered the audio." Second is an email from former Chief Administrative Circuit Court Judge David King, indicating he's fully aware of that. And third is the August 26, 2022 partial deposition of Judge David King, where he's under oath and being asked about the transcript. And these are all widely available online for anyone watching. Just go to judgeking.com or Google Judge King deposition. With that said, as to the need for the bill, I would sort of repeat most of what Rep. Leon said, but you already heard it from her, so I don't have to. So let me drill down on the specific need here and some of Attorney Markell's, sir, how do your name, forgive me, Markell, comments on the accuracy of the record. What's very problematic here is when we're simply creating an inaccurate record deliberately to cover up judicial misconduct deliberately. And if you look at page 26, this transcript is redacted, the deposition is redacted. I've been unable to get the whole thing. If you look at what's supposed to be page 26, lines 12 to 16, you'll note 5 points. Number 1, Judge King was under oath during the deposition. Number 2, it appears that Judge King knowingly lied by stating that he informed the Judicial Conduct Committee about his findings regarding the transcript, when in fact he did no such thing. Point 3, it appears he intentionally did not disclose his findings to the Judicial Conduct Committee, fully aware that his deposition statement was false. Number 4.
You have about 1 minute.
Yes, very material, thank you. Caused significant delays lasting several years, which necessitated the New Hampshire Supreme Court's orders for multiple revisions of the initially falsified transcript. And point 5, he made this false statement in a legal context where he was under an obligation to tell the truth. And so that's just to address the accuracy of the record, and just a few other comments on the domestic violence piece to respond.
I'll give you about 30 seconds.
Okay.
Is that fair?
That's fair.
Thank you.
I was most recently denied the opportunity to film a family court proceeding at the request of a domestic violence victim because the perpetrator said no, even when I went through the standard channels that exist today to do that. And it's my understanding that's highly irregular. That was last on January 15th. If you want, I can give you more details, but you said 30 seconds, so let's leave it at that. And I'm happy to take questions.
Thank you. Any questions for Mr. Albrecht? Seeing none, thank you very much for your testimony and the handouts.
Thank you.
Next, I'd like to call the Honorable Betty Gay. You've asked for 4 minutes. I'm going to ask you to take your seat, and then I have some business to take care of, please. It is now 1:45. We are scheduled for a hearing on House Bill 335 at 1:45. So I'm going to recess the hearing on House Bill 350 for an announcement. I'm going to open the hearing on House Bill 335 at 1:45, and I'm going to recess it until we finish the last 3 speakers on House Bill 350. Without objection, may we proceed? Thank you. I will recess the hearing on House Bill 335, and we will get back to it as soon as we finish House Bill 350 with the indulgence of all those who've come to testify. We are now in recess of House Bill 335, and I will reopen the hearing on House Bill 350. Thank you, Honorable Gay. You may proceed.
Thank you, Madam Chair. This is not one of those fun bills where everybody says, oh, thank goodness we finally have this. I've been meaning to do it. I have submitted this bill in another form twice because we found out that if there's a breakdown in communication deliberately between people who are in family court, and supposedly it is for protection, privacy protection, but that means that people don't get to know each other's troubles that are happening in court. And it became apparent to me as a rep when I was appealed to by victims of bad practices in court, when they would look forward to getting their, excuse me, their recordings that they paid for, all transcript. You can buy the recordings and they're very affordable, like $35. Paying for a transcript, you're talking into thousands. So lots of people are priced right out of the market. They can't, and they're not legally permitted to make their own transcripts, which I think is very unfair. So one of the problems is they would look forward to getting their recordings because the judge said something that they absolutely should not have said. And then they find out it's been deleted. So if one person said that to me, I'd be a little suspicious. No, several people have told me that. So we're not talking about a friendly discussion on policy to change family court. Plenty of people who are employed by the court do not like the changes. So we are in a hostile environment to come in and say we need some changes here to make the playing field fair. Historically, recordings are edited. And as the man who just testified, he has written proof, an email from transcribers where they say very openly, well, we clean up, I'm using my own terms, we clean up what the judge says. If they think it's not worthy of a judge, they'll make it nicer. So we finally had a person who could watch the judge. So they have the transcribers cleaning up the language. We also have a person who was watching. They just happened the judge wasn't behind a solid you could see their feet. She could see him turning it off and on, and that would explain why there were clicks in the recording. When he was saying something like, "You're not going to like this," or something else that wasn't really polite, he'd turn the recording off. This has to stop. And if people can make their own recordings, I don't have to have it played out to the world. I just want people to have the right to make the recordings, and then they can still buy the recording. That's still the official. But if their recording doesn't match the official recording, I think we'll see a change in the behavior of the people processing the recordings, because there should be punishment, or lose the contract if you're going to do that. So I think if a crime against a child
30 seconds.
If a crime against a child is being discussed, family court probably isn't the right place. It probably should be in criminal court. So I think to protect the child, the truth has to come out, and the recording is a necessary part of the truth coming out. Thank you.
Thank you. Any questions for Ms. Gay? Seeing none, thank you very much for your testimony today. Next, I'll call Gail Drobat. In the interest of time, Ms. Drobat, you've asked for 3 to 5 minutes. How about if
It'll be
we
quick.
break it even at 4?
It'll be quick. Yeah.
Thank you, ma'am.
So Gail Drobat, for the record, Amherst, New Hampshire. I'm in support of this bill. Part 1, Article 8 of our Constitution ensures that magistrates, officers of the court are accountable to the people. Our courts are open and accessible to the people. Family division rule, again, is open to the public. Hearings in the family division are open to the public unless otherwise specified by state statute or order. Cases under 169C Protection Acts provide appropriate restrictions for that. So those can be restricted. Audio and video recording of family court proceedings will benefit both litigants and court officials by providing a precise, accurate, and accessible record of the proceedings. This ensures that all statements, testimony, and judicial rulings are clearly documented, reducing the risk of misunderstandings and misrepresentations for litigants. It creates an official and transparent record that is crucial in the event of an appeal. Ensuring fairness in the judicial process for court officials, recordings provide an efficient way to review proceedings without the need for extensive transcripts, ultimately reducing costs. This method also promotes accountability, consistency, and family court decisions. Audio-video recordings protect all parties to the case. It protects the courts and the litigants. And I just want to point out, there was questions about other states doing this. Nevada, our audio video recorded in every county, and you fill out a form, you request the recording on a CD or a memory stick. So they also are recorded in Kentucky. So I don't know, you may want to somebody look into that and see, or they're going to email me some information on it. So I'm happy to take questions if you have any.
Representative Nelson.
Sorry, she was. Thank you, Madam Vice Chair, and thank you for taking my question. I will look into it some more. I haven't. Thank you.
And I can give you some contact
Is that
information.
live broadcast permission or audio?
I
and
think
video?
it can be. That's just audio video that they can request.
Okay, thanks.
So I'll give you the contact information. Yeah.
Seeing no further questions, thank you for your testimony. I have one final pink card. It's from Erin Cregan, who has made herself available for questions. Does anybody have any questions for Ms. Cregan?
And sorry, just introducing myself for the folks at home, General Counsel for the court system.
I was just going to ask you to do that. Thank you for introducing yourself and coming forward. Any questions? Representative McMahon.
Thank you, Madam Chair. Thank you for taking the question. Do we need this bill?
As a member of the judicial branch, I would always defer to the legislature on whether to pursue a bill or not. I would not want to advise you. I do understand, and I think you hear it, there are different interests. There's transparency and then there's privacy, and those can come into pretty direct conflict, and those are very difficult to balance. So I don't envy you the job that you have. There are some options people have now. They can request to record, or they can seek a copy of the video surveillance, the security video surveillance, which does not have audio, but it is a form of video. I understand the purpose of this to be to try to create more transparency. As the court system, we want people to have confidence in the work that the courts do. But we also want people to feel safe and secure in family division and feel that they can discuss some matters that are very, very intimate and often very private. That's a challenging balance. I appreciate the conversation that I've had with some of the sponsors of this legislation to make some changes, including potentially not being live, potentially being recorded rather than live, so that things could be redacted if they needed to be. Starting with one courthouse as a scaling measure to see how it were to go. And I think also considering more judicial discretion was something that the sponsors were thinking of as well to deal with individual circumstances. So it's been a very good dialogue, but I would not want to comment on whether the legislature's determination should be whether to move forward with the bill or not.
One follow-up, Madam Chair?
Follow-up?
Thank you. Relative to the genesis of why the bill is here, can you comment on our judges selectively revising the records after the fact?
I have no information suggesting that. I do know that there is an instance where a judge under their breath said an expletive, and the e-scribers did not know whether to transcribe an expletive or not. The person was fired as a result of that incident.
Thank you very much. Thank you, Madam Chair.
Thank you. Representative Gregg.
Thank you, Madam Chair, and thank you for being here and taking my question. So I just wanted to know if, is there any kind of a judicial review or anything if a judge cuts an entire section out, or is there any a check and balance on that kind of stuff?
It's a great question. In our superior courts, if you've traveled to them, you may know that there are court monitors who are listening the entire time, and they're very careful and they're checking the records. Our circuit courts are just not staffed that way. Typically, it is just the judge and a court security officer in the courtroom, and the court security officer, in addition to scanning for potential security issues, flicks on the record when they see the judge come back to the bench and flicks it off as the judge is leaving. I don't think it's impossible that someone's made an error. I don't have a reason to think it's something other than an error, but typically when the judge is not present, the record is not on, and people in the courtroom are speaking freely without being worried about being recorded.
Representative Love.
Thank you, Madam Chair. Thank you for taking my question. You know, in talking to constituents of mine, the family courts, the confidence in them is at an all-time low. We need transparency. Would the judicial system be adverse to doing like I asked Representative Leon to streamline this to just the people can get the litigants can get copies of the proceedings. So if they have to go on and you know go to Superior Court or whatever, they'll have it at a reasonable cost. You heard Representative Gay talk about thousands for transcripts. You know, we've got to do better than that, especially where so many people are doing pro se, and that's because they're broke. Okay.
You're completely right that most people who appear in the family court appear without a lawyer, and that this is a very intimidating process, and often this is the worst thing that will ever happen to them. They're getting divorced, they're the subject of an abuse and neglect case, they have to seek a civil protective order. This is maybe the worst day of their lives. And they're coming without a lawyer to a court system. That's a very intimidating process. Completely want people to have confidence. So we want to be partners in the measures that legislators are taking to increase that confidence. People can record, if that may be an option for them. I think I would just need more legislative guidance on whether this subsumes confidential hearings and how that would be protected or whether this is only not confidential proceedings, whether the court is allowed to order that they not disseminate it, or whether they can't order that because the legislature has made a determination that it is something that can be distributed. So I think that there are things we can do to instill more confidence, but I would still expect that the record is turned off when the court is not sitting. So it may be that you experience some of these same concerns that folks have, that the record is off for a period of time. What I might suggest to someone, if they're worried about that, is to get the security video and see that it'll run through because it has no audio, and they'll be able to see the full run through period, which is a process that they can request right now.
Follow up?
Yes, ma'am. What would a recording without any audio do for anybody?
It would show you, if you match it with the audio, which you can also order, you can see what periods of time are not recorded. So when that the judge is off the bench, that there's not a witness speaking. And I know that that's labor intensive, but there's at least some potential check there. But your point about transcripts and the costs, I mean, you're right, they can be expensive. This being New Hampshire, we completely outsourced the transcript process to a private company, which does them at order. As people order them, they pay for them. It is not a service we do in-house, so it's not a situation where we have the transcript and we're not giving it to someone. We don't have it. It's a private company that's making it on request as people order it.
Any further questions? Seeing none, thank you so much for your time.
Thank you.
Have a great day. With that, I will close the hearing on House Bill 350 FN, and I will open the hearing on House Bill 335 FN at this time, and ask all those here to testify on House Bill 335 to forgive the lateness of opening this hearing. And the first person I'm going to call is the only pink card that I have at the moment. Representative Caitlin Katab. Can you please introduce yourself? And thank you for coming.
Thank you, Madam Chairwoman and members of the Children and Family Law Committee. For the record, my name is Representative Caitlin Kutab, and I am introducing House Bill 335 on behalf of the prime sponsor, Lisa Post, who could not be here today. I have just passed around an amendment from Rep Post, which all of the co-sponsors are also on the amendment. The biggest thing that this amendment is seeking to change.
We have to speak on the bill, not the amendment.
Okay, I'm going to reference the main bill as I talk. It's one word change, just so that we know. So it's.
I'm sorry, ma'am.
No. So when the main bill was written, the intent was that the court may order a risk assessment within 14 days in certain circumstances when they are worrying that there may be some sort of a family conflict or that the child may be showing signs of abuse or rejecting the other parent, that they may be able to order it. Unfortunately, what had originally come out said shall, and so this amendment changes it to may. So when you're looking on the original bill, it is on line 8. That word shall is being changed to may by the amendment. I do think that it's really important that we're able to give this tool to the court. It's enabling legislation. It's not requiring anything. This is if the judge feels like this is a necessary thing to do, that they're able to do this. And I'm happy to take any questions on this bill.
Thank you for your testimony. Any questions for the representative? Representative Raymond, and this will be on the bill only.
Okay.
Thank you.
Thank you, Ms. Chairwoman. I think my question applies just fine for that. So thank you for taking my question. My question is about who will be doing these assessments. Is there an anticipated court appointed pool of people to the assessments? Is it the CANS assessment that DCYF uses, or is it up to the participants to identify their own therapist and then have this assessment done? Oh, and is there a standard assessment that exists that would be given, or is it completely up to individual providers? That was a bunch of questions. Sorry.
Thank you for the questions, Representative Raymond. So the bill is specifying that it does have to be a clinical psychologist who is credentialed in this specific area. And so it would be somebody that would have to be credentialed in this specific area. It wouldn't be somebody that's a court employee, so to speak. It would be a private provider. And we're leaving it open to the judge, rather they want to recommend a certain provider, or the parties perhaps want to agree on a provider on their own. Again, this is a may type thing, so I think it's really important that we leave that leeway up, because perhaps there is already a provider associated with the family that the child is really comfortable with and would prefer to use, rather than a stranger that maybe suggested that the child doesn't know, particularly if there's already some ongoing trauma of some sort. We wouldn't want to kind of re-traumatize the child by having to go and talk to somebody different.
Follow up?
Thank you. Follow up.
Thank you. So is there a definition for what is included in a risk assessment?
Yes, so that would be starting at line 21.
Okay.
Thank you. All set?
Well, I'm just wondering where the definition came from. Like, is this a common thing that's in like the
Follow
DSM-IV?
up? Is that your follow up?
Yes, that's my follow-up. Just
Thank
to
you.
clarify the follow-up.
It is my understanding from the sponsor that this language, she worked with a psychologist on this language that is familiar with this, very familiar with this field, is an expert in the field, and provided this language based on how this is typically done.
Thank you,
Representative Rice.
Thank you, Madam Chair. Thank you for taking my question. Who's going to pay for this?
Thank you for the question, Representative Rice. So in the bill, it is requiring that the cost shall be equally borne by the parties.
Follow up?
Follow up.
I have a follow up and I lost it. Dang it.
Would you like me to come back to you?
Yeah, please.
Okay, Representative Nelson.
Madam Vice Chair, Representative Scher was waiting before me, so I'm glad to.
I apologize. I did not see Representative Scher.
I do best I can to hide.
You did a great job.
Thank you. And thank you, Representative Nelson. I have a daughter who's a clinical psychologist, and I'm aware how many different kinds of specialties there are for clinical psychologists. My concern is in a state like New Hampshire, where there's not even as many clinical psychologists as there are in Rhode Island, where my daughter works, that we're creating in the mind of a court the possibility, the reality that, boy, I can have a clinical psychologist help me make this decision, when in fact it's not the case. Do you know if the prime sponsor has any sense of whether there is a large enough pool to make this practical?
Thank you for the question, Representative Scher. It is my understanding that while there are not an overabundance of these providers, there are several of these providers within the state in different geographical areas of the state.
Follow up?
Just follow up.
What if one of the parties can't afford a clinical psychologist? What happens then?
Thank you for the question. So this is a may type of a thing. So if the judge deems that, hey, the parties can't afford it, then in that case, he wouldn't be ordering it. This is not, I don't think we're in a financial position right now that we would be able to bear the cost of such evaluation on
on the court. I think it would have to be the parties paying for it.
Thank you.
Representative Nelson.
Thank you, Madam Vice Chair. That question was asked, and I appreciate it. It was asked very nicely by Representative Sharp.
Thank you, Representative Nelson. Representative Rice, did you remember?
Thank you, Madam Chair. It came back to me.
Yay.
So, as someone who has had some therapy and all of that, I know it's not readily available to get in right away. We do have a shortage. Are you sure that, because this is ordering that it be done within 14 days of the initial petition for divorce, and what would happen if that can't be done in 14 days? Because that's like 2 weeks. Like, I can't get in to see my therapist that quick.
Thank you for the question, Representative Rice. So this is requiring that it's ordered within 14 days of the petition, but it's not actually requiring that the assessment take place until on page 2, lines 3 and 4, that it shall be within a reasonable period of time, not to exceed 8 weeks after the order.
Okay, thank you.
Any further questions? Thank you, Representative.
Thank you.
Next, I'll call Betty Gay. You've asked for 4 minutes.
Thank you very much for allowing me to talk about something that is dear to my heart. All the questions that you're asking are really good. What you don't realize is those questions could be used for what is going on right now. There are several. This again is to address a really bad thing that's happening in some family courts, and that is that the judge is ordering. And we need to talk about judges sometimes, because that term is not correct for most family court judges. It's a different term, and it's a different legal. They're supposed to do that job, but that's also a whole subject that family court is different on. The same questions you're asking need to be applied to what happens usually in family court, and that is that counseling is ordered. And they don't have to pay for it. The court doesn't. They don't order it in my experience, they don't order it for people who are indigent. They order it for people they think can pay. And it's really crass at its worst. I knew somebody who was ordered to more counseling for both her kids and for her, not for the other parent who was the abuser. More than her cost out of pocket would be more than she made cleared per week. It didn't bother the judge because he knew her parents had money. And they actually told her, your parents they can pay for this. Now that's got to be illegal, but it was done for years. So this bill says before you order counseling, and all your questions about who's going to pay for it and how does it order it and how long is it going to last, all of those questions should be applied to what is happening right now, because counseling gets ordered all the time. And of course, the court doesn't pay for it. Let's say, why not, if the first counseling you're going to order is evaluate the people there and see if they need counseling, and if so, what kind? So this is just saying, if you think counseling sounds like a good idea, first have the people evaluated. Don't just start ordering counseling for months at a time. It was tragic.
1 minute.
So I hope I've said this. If you can make me clarify what I'm saying. If you're going to order counseling, let's first do an evaluation to see what kind should be ordered, and maybe even if it should be ordered. I think counseling is very useful. I'm not against it. I've certainly gone to my share over my decades. So I'm not negative at all about counseling, but let's figure out, because the judge usually isn't a counselor, who can figure out, the best assessment
30
himself.
seconds.
Thank you.
Any questions? I give my, Representative Seidel.
Thank you, Madam Vice Chair. So are you in support of this bill or opposition?
Oh, I'm very much in support of this bill.
Thank you.
Thank you, Honorable Gay. I appreciate your time and your testimony.
Thank
Any
you.
more questions? Thank you. Next, I'll call Mr. John DeJoy. Mr. DeJoy, you didn't specify any particular amount of time, so I take it you're going to be as brief as you usually are.
Thank you, Madam Chair. And I will be as concise but robust in my testimony as I'm able to.
I would expect no less, sir.
Thank you, Madam Chair, members of the committee. It's a pleasure to be before Children and Family Law. For the record, I am here representing the National Association of Social Workers, as well as the New Hampshire Psychological Association. Both of my clients are strongly opposed to this legislation. This legislation is well intended, but it is actually a solution in search of a problem. I was contacted by the prime sponsor and a constituent of hers week before last, and they asked to meet with me, which I did with my client from the social workers. We had about an hour-long meeting and talked about this legislation, talked about the amendment before you. I won't discuss it. And talked about what their concerns truly were. This bill, we initially began opposing this because it mandates an evaluation. We are always opposed to courts mandating an evaluation just offhand. There needs to be a reason for an evaluation. The court can determine that, but there needs to be a reason. The bill and the amendment do not provide that necessity. Through the conversation, though, the constituent of the prime sponsor mentioned several times that her concern was that judges can order these now, but they just aren't. Judges aren't ordering evaluations. And she said, this bill is to make sure judges always order evaluations. As we talked more and more, it became clear to us that this is not about kids being evaluated. It's not about evaluations at all. This is a process issue in the court that the constituent does not like the way the proceedings are going. And I don't know whether her concerns have merit or not. They might. But I do know that by re-traumatizing children through these mandatory evaluations, that's not going to get her to where she wants to be. I actually said to her, even if this bill passes, you will still be disappointed in 6 months, because what you want to happen is not going to happen. We encouraged her to talk to the administrative head of the family court. I also spoke with the prime sponsor and walked her through some of the pieces of a performance audit. That this really ought to be with Chair Pearson and the task force he's working on regarding the family court, or perhaps a performance audit of the family court to understand what truly is within their jurisdiction as judges and what's happening within the court system that might be amenable to some kind of administrative or legislative change. This bill isn't that.
Thank you very much. Any questions for Mr. DeJoy? Representative Raymond.
Thank you, Madam Chairwoman, and thank you for taking my question. So what is the breadth of what judges can order now, as the law currently stands, in cases of a divorce or a parenting plan that, is a little bit tense?
Representative, I thank you very much for your question. Unfortunately, I'm not a judge nor a lawyer, nor do I play one on TV. I would turn to the gentleman to your left, who is a lawyer, and might be able to provide additional detail that I would not have any way of knowing.
Follow up.
Thank you, Madam Chairman. So maybe more in your wheelhouse. In the bill, under Section 2, it lists all of the things that would happen in a risk assessment. Is this stuff that a psychologist would be able to answer or do in a one-time meeting with a child?
So this is the other reason why we were opposing the bill. It's not what they're going to look at. So a risk assessment typically, what a risk assessment means both for social workers and psychologists and other mental health professionals, a risk assessment means, is the person at risk? Risk typically is determined by suicidal ideation and intent or homicidal ideation and intent. That is typically what is risk. You can, as a mental health professional, do a risk assessment of whether a child is a risk of running away from a program, of whether a child is at risk of some other feature. But a risk assessment in and of itself does not look at shared or induced persecutory delusions, which, quite honestly, there is not a scale that I'm familiar with that assesses for persecutory delusion. That is learned over time through therapy. Not typically, except in extreme cases, not typically from an evaluation. What this really sounds like is another way to go at you had a bill last year on family. Thank you, Representative. You shared it. There is one of the courts or two of the courts in the state last couple of years have been requiring evaluations to try to reconnect the family through treatment.
Reunification.
Thank you. So we oppose reunification because it's not a treatment. It is not a treatment by any recognized body of practitioners. What it is it's a way to coerce a child and or a spouse into reconnecting. The way these read, Representative Raymond, is similar to what the intent of reunification therapy was.
Thank you. That was my amendment last year. I rewrote that bill, so I appreciate it. Thank you, Madam Chairman, for your indulgence.
You're welcome. Any further questions? Representative Love.
Thank you, Madam Chair. Thank you for taking my question. I've got more than a few constituents, male and female, who have said that the children, and you use the word coerced, and that's the one I want to put on. They're being coerced into hating, staying away from people. We had a woman testify earlier on a grandparents' bill, how her grandchildren are being coerced to not even look at her when they're playing sports. Wouldn't this bring out a coercion of children? How low can you go using children to and I think the court needs to address it, and this would just put an emphasis on, hey, court, you're missing out on this. It might already be in statute, but you're ignoring it, and it's just a reminder that they should be.
Representative, I think let me try to pull out the question that I heard to respond to you. And as I said, my clients are not experts in the court system. They're not indicating that there's no issues with court process. They're indicating that this approach to address a court process issue is not the way to address it. Would an evaluation detect coercion? I suppose in extreme cases it could. But it's equally likely that the coercion wouldn't be present, or the child wouldn't even talk to the therapist. There's a lot going on in family court. There are unfortunately winners and losers through the family court process. And many times folks who are not on the prevailing side feel as though they didn't get a fair shake, and they may not have, but they just as likely may have. Forcing a kid through evaluations of this sort don't address that, doesn't change that. I've been before this committee many, many times over the last decade, and typically I am testifying in support of keeping families together whenever it's possible. I think that is the best benefit for the child, the best interest, I think Representative Raymond asked before, the best interest of the child is typically to have two loving parents. We can't legislate that. That's the truly unfortunate part. We can't legislate parents to be loving parents. I'd like to think that every parent is a loving parent and cares for their kids. I really do. And that's where I start from. But I've seen stories in this committee that call that into question.
Thank you very much for that. You all set? You all set, Representative Love? Thank you, Representative Scher.
Speaking only as the gentleman to the left of, I'm looking at RSA 461-A:4, and as I read it, it asks the court to develop a parenting plan. Roman numeral 1 asks the court to develop a parenting plan. Is it fair to say that even without this legislation, the court can say to the parties, hey, it would be helpful for me if we could have the child or children at issue talk to an individual, a clinical psychologist or a therapist of some sort. As far as you understand it, that's not prohibited currently, is it?
My understanding that could happen today.
Thank you.
Thank you again. Any further questions? Thank you, Mr. DeJoy. Next, I'll call Mary Kruger. Mary, you've asked for 5 minutes.
Yes, thank you. And thank you, Madam Chairman and members of the committee. My name is Mary Kruger, and for the record, I am an attorney with New Hampshire Legal Assistance. We are a statewide civil legal nonprofit providing services to people in poverty. One of the projects that we operate is the domestic violence advocacy project, of which I'm the supervising attorney. Last year, we completed just about 240 cases, which would include protection order cases, divorce cases, and parenting cases. Our victims that we represent suffer high lethality violence. So these are the most risky cases that go through our court system. I'm here to oppose HB 335FN on behalf of New Hampshire Legal Assistance, and we're doing this mainly because there's a few reasons, but one, there's a strong policy in our state really to consider the children's best interest in these cases and to really do no harm. This bill, if enacted, would harm children, exposing them to very invasive and evaluations where they're really thrust into the middle of a contested parenting case. That alone is damaging to children. I've testified before about how our courts really encourage parents to try to reach agreements and try to think of the best interests of their children. So we're talking about the cases where that's not happening. Right now, the courts can appoint guardians ad litem, and their job is to investigate issues that the court has or the parties have raised at issue in a contested divorce and parenting case. And that system does have its issues, and I've been in front of this committee over the last probably 10 years talking about that. However, that is a system that exists where a guardian ad litem could do an independent investigation for the court when there's allegations that one parent is trying to turn the children against the other parent, which I think this is what is being addressed here in this bill as I read it. And I wanted to point out for this committee that there's a case called In Re Berg, And I put it in the footnote to the written testimony here for an important reason. And it talks about the right of privacy of children in these contested cases where neither parent is permitted in a contested custody case to invoke or waive a privilege for a child from their therapeutic session. And that way the therapy session is considered a confidential space for a child to be able to process everything without being discovered by either parent as to what they're disclosing. And that's important to the therapeutic process. And that case really talks about how that outweighs a parent's fundamental right to parent a child in these cases. And I think it's really important because this implicates that privacy issue for children and could be really harmful to them if it's enacted. And there's other ways for courts to get at this information already. So we're asking that this committee vote ITL on this bill. Thank you.
Thank you. Any questions? Representative Rice.
Thank you, Madam Chair. Thank you. I didn't get a copy of the written testimony. Can you email it to me so I can see that link?
Yes. Yeah, I did make 16 copies, so Representative Scher maybe snagged one.
Never mind. Thank you. Thanks so much.
And I'm also happy to circulate the In re Berg. I didn't make copies of that. I have one here with the committee like that. Okay. It's a really good case, I think, for a lot of the issues that you're handling here.
Would you be so kind as to turn that in for the file so if anybody wants to refer to it, they can?
Yes.
Thank you kindly. Representative Scher.
Thank you, Madam Chair. In the interest of transparency, the person testifying had the misfortune of being a former student of mine. So thinking about the guardian ad litem, the guardian ad litem job is to connect with the child if it's appointed for the guardian ad litem and develop, ideally, a relationship with the child. Is that a fair way to put it?
They wouldn't necessarily develop a relationship with the child. In my experience, they might meet with the child once or twice, depending on how long the case is going along. So, but they can talk to a child's therapist, and that's one way to protect that confidential information. And they can get orders to ensure that that be kept confidential, but they can utilize that information from a therapist to inform how to make recommendations to the court about what's going on.
Thank you.
Thank you for your testimony.
Thank you.
Chair recognizes Gail Drobart. Asked to speak for 3 minutes. Let's see how you do.
Oh, sorry. For the record, Gail Drobat, Amherst, New Hampshire. I'm in support of HB 335, and I appreciate Mr. DeJoy's testimony. I did meet with him, and this bill came to light because of his previous testimony on reunification therapy, that a risk assessment, if anything, should be ordered by these judges. They should be ordering nothing more than a risk assessment. So that's how this bill came to light. Testimony before this committee over and over, children being withheld from a parent, whether in a contentious custody case or allegations of abuse or neglect to DCYF. The interference with custody could be for weeks, months, sometimes years. HB 1162 in 2020 outlined psychological maltreatment, and prior to January 1st of 2021, the Department of Health and Human Services, Division of Families, in partnership with the New Hampshire Coalition Against Domestic and Sexual Violence, shall provide training to DCYF child protection staff, court-appointed special advocates, family court judges, and other victim partners regarding the implementation of Section 51 through 54 of that Act. Interfering with the child-parent contact should be a last measure, and when the court has a compelling state interest to do so. Forcing children to mourn the loss of a living parent and forcing a parent to mourn the loss of a living child has lifelong consequences for both, as well as extended family. For these reasons, please support the passages of this bill, the mental and emotional state of New Hampshire children, and protect these children from a childhood filled with trauma. Allow them to have a childhood they do not have to recover from.
Any questions? No.
And there is a risk assessment from a clinical psychologist, protocols for a risk assessment. Consider that in your, thanks.
Chair recognizes Dana Albrecht. You're even more brave. You asked for 1 to 2 minutes.
Thank you, Mr. Chair. Can we go up to 3 given the amount of comments I've heard? Dana Albrecht, Nashua, New Hampshire. I heard it said earlier that this bill is a solution in search of a problem. I submit I'm the problem that this bill is a solution for. I've heard it earlier said that we have winners and losers in family court because it's an adversarial process. I respectfully suggest the committee question that. Why must there be winners and losers? Why can't there be winners and winners? I've heard concerns raised about what does this cost? I suggest, at least in my own case, it would have cost far less than over $10,000 in GAL fees, where the GAL is a lawyer and the best friend of the judge. Would cost less than 6 figures of lawyer fees in an adversarial proceeding. Why are we subjecting children to adversarial proceedings if there might be alternatives? Why can't people trained in therapeutic modalities have a crack at solving some of these family conflicts in divorce cases sort of before we escalate the conflict up to, you know, let's just go at it with a lawyer for mom, a lawyer for dad, and another lawyer for the kid, none of whom are trained in therapeutic modalities. Many other states like California, at least for the GAL piece, assign that sort of evaluation to someone trained in therapy, not law. And so I would just submit to you, I support this very, very much. As fond as I am of shall, I think may is fine. But I would very much like to see this passed, and it would have gone a whole way to reducing all of the burdens on the judicial system that cost so much money, so much pain, and so much trauma over 7 years of protracted litigation. With that said, I'll take questions if there are any.
Any questions for Mr. Albrecht? Seeing none, thank you for your testimony.
Thank you.
Welcome back.
Thank you.
Chair recognizes Sarah Tollefson.
Hello. My name is Sarah Tollefson, and I come before you today as a protective and caring parent from Goffstown to speak in opposition to House Bill 335. As someone deeply invested in the well-being of children in our state, I feel compelled to raise several serious concerns about this legislation. First, I must address the concerning lack of transparency surrounding this bill. I attempted to contact the primary sponsor of the bill twice to learn more, like what individuals or organizations brought this to their attention, and have not yet received a response. This committee and the public deserve to know whose interests are truly being served by this legislation. The practical implementation of this bill presents significant problems. It directly conflicts with the law passed in 2024 prohibiting reunification therapy and appears to be merely a repackaged counterbill. The provisions regarding reunification therapy and the requirement for therapy to be recommended by both parties and accepted by insurance are in direct conflict with HB 335. Of particular concern is the requirement for court-ordered psychological evaluations and risk assessments. These evaluations, which typically cost thousands of dollars, are not covered by insurance. Furthermore, finding qualified providers who can complete these evaluations within the bill's 14-day requirement is virtually impossible in our state. This creates an unreasonable financial burden, particularly impacting domestic violence survivors, who may already be struggling with limited resources, and it is not uncommon for coercive control perpetrators to intentionally force former partners into financial debt or impoverishment using the family court system. We must also consider the traumatic impact of mandatory psychological evaluations, especially on children. As a caring and protective parent, I cannot emphasize enough how forcing children to undergo such evaluations can cause lasting psychological harm. We do not want to be an institution contributing to adverse childhood experiences. I challenge this committee to investigate who stands to financially benefit from this legislation. More importantly, I urge you to find even one documented case where forced therapy successfully restored a resistant parent-child relationship. Love and connection is organic and willing. Therapy as well, by its very nature, cannot be forced. When we attempt to do so, we strip it of its healing potential and transform it into a punishment, the very opposite of its intended purpose. Therapy is a powerful tool of resiliency, and we do not want to remove that tool from the toolbox of parents and children who may come to need it now or in their future by making therapy a painful, coercive, and negative experience. At its core, this bill appears to be built around the concept of parental alienation syndrome, a debunked theory that has become the only mental illness, apologies to the man on the left, diagnosed by attorneys rather than mental health professionals. Parental alienation syndrome is frequently used as a counterclaim in family court when abuse allegations arise, potentially putting children at risk. There is a reason why you are not seeing the words reunification therapy or parental alienation syndrome in this bill, although the alternative words used in it are just a guise. Our state just prohibited this very act HB 335 proposes. Children are human beings with valid feelings and experiences. They, like adults, naturally withdraw from situations where they feel unsafe or neglected. It is not a syndrome requiring forced intervention when a child resists contact with someone who has caused them harm. It is a natural, protective response. Let's keep our attention where it best serves the safety and well-being of children, identifying and preventing abuse and neglect. As legislators, parents, and community members, we have a fundamental responsibility to protect New Hampshire's children. This bill fails to serve their best interests, lacks transparency, and will cause more harm than good. Thank you.
Will you take questions?
Yes.
Questions for the witness, anyone? Seeing none, thank you for your testimony. I have no more pink cards on 335. And I don't see anybody making a mad dash for them. So with that, I will close the hearing on House Bill 335. And a couple of things for the committee, please. Number one, we are getting growing pressure from the Speaker's office. They say that we have a habit of sending them bills that go on a consent. Well, all committees should be like us then, I say, but I know what they mean. And so 2 weeks from today, we're going to exec every bill that was heard 2 weeks ago, last week, and today that have not yet been execed. We'll do that on that Tuesday morning, 2 weeks from today. So if you want to work on them, if you have amendments, get it done. We'd like to see the amendments ahead of time if possible, so we can come ready to discuss. So that's item number one. Item number 2, the Bill HB 10, which is Parental Bill of Rights. I just testified before a committee, and I said, if you've read my bill, ignore it. Here's the amendment, which is a replace all. And sometimes that happens. We weren't ready, new evidence comes to light, there was a deadline, what have you. The amendment to HB 10 that I'm passing around, if you could take as many as needed that way, and I'll pass the rest this way. This is the amendment to HB 10, the Parental Bill of Rights. I'm giving you 2 weeks notice on it because 2 weeks from today in the afternoon, this is what we will be looking at. So this will give you that advance notice. Perhaps we could let the 2 members who are not here today to know to access this. Do we have enough copies? I have another copy here coming around, Representative. In fact, I have everybody have one? Everybody.
We might
So-
want to leave 2 with the clerk for the 2 members who are not here, so they
well,
can
I'll let you
No
guys
worries.
figure that out. Okay. What am I bid? I give you $5.
$2.98.
What? $2.98. I'm not giving you a discount. Okay, here's another one. Okay, I'll leave it here. All right, I'll leave it here. All right, any questions on that? We're going to look at this. I doubt we'll exec it 2 weeks from today, but we are definitely going to have a hearing, probably a good bit of that afternoon. Every other bill that we've looked at that has not yet been exec. If you want to write amendments, fine. If you want to do other things, that's fine. The subcommittee I appointed this morning, Representative Gregg will be in touch with you as to when your first meeting will be. And if it's soon, get that information to Special K so it can go into the calendar, please. Okay? Anybody else, committee? We wish to thank our visitors today. Feel free to come back, both of you, including the lawyer, anytime. That lawyer, you're already here.
Excuse me, I believe it's the gentleman on the left from now on.
We do recognize you as the gentleman on the left. This concludes our hearings today.
Yeah.
Oh,